Is 2.
May I please, Lords?
Yes, please.
Here the funds of the tribal people have been misappropriated even after the inquiry and direction by the state government. No action has, Your Lordship, may kindly see page 46.
Let this be sent to the loci better. You
Your
see,
Lordship, may
given the subject matter of the grievance, the court is of the view that the petitioners should approach the lokaayukta with an appropriate application, permitting the petitioners to do so, the petitioners disposed of.
Item number 3. May I please, Lord? This matter is related to PIL matter. A large number of villagers of a different village have approached the competent authority to misappropriations of government's funds, my lord.
So again, you should go to the lokaayukta, please. For all this. Same order, given the subject matter. All right.
Oh, bless me. High lord.
All right.
This submission item number 4.
4, my lord.
Yes.
4.
My lord, already covered by Your Lordship's order. Similar order may be passed.
Yes.
Bajaj. Short judgment.
Lordship,
Para 10, my lord.
in that case, there is in the first paragraph 1999-2000 till 4-5. Actually, that has been wrongly quoted except 2003-4, and this is 2003-4.
This is 2003-4.
I see. All right. You say in view of the order passed by this court on 31st March 2021, in its petition civil 3804 of 2018, bracket Messrs. Bajaj Auto Limited versus Deputy Commissioners. The present petition, which pertains to the year
3-4, my lord.
2004, is disposed of in the same terms. All right.
Item number 5.
This matter, my lord, relates to correction of as a GSTR 1, my lord. Instead of B2B, it was B2C, my lord. A similar matter is pending before your lordship's court, my lord, in WPC 18216 of 2021, my lord. That is Shiva Jyoti. But the next date, it has been admitted on 30th June this year, my lord.
All right.
But the next date has not been given.
Oh, I see.
For party number 1.
Who's for the GST?
It's a GST matter, my lord.
I know.
I'm praying for a correction. My lord, it's central.
All right. Notice he accepts notice on behalf of the opposite
1,
parties.
3 and 6. 1
to 6. 1 to 6. Notice will now go to opposite party number 7, returnable. It's a date in 4th April. List along with writ petition civil
1821-2021.
1821/2021. Is there interim order in that?
No, there's no interim order.
Okay. All right.
I'll just take out notice on opposite party number 7.
7. That's right.
Greatly obliged.
Replies be filed within 8 weeks of service of notice. Rejoined if any before the next date.
Extra
Obliged.
copy may be served.
I'll serve extra copies.
Right.
Item number 6.
May I please, Millards?
Yes, please.
Millards, I am appearing through VC, Millards.
Yes.
Millards, in these matters, Millard, there is a challenge to Rule 89.4, which Millards have heard in Vedanta case. Millard,
Right.
it's somewhat similar to that. Challenge to Rule 36.4, Millards.
All right.
And there is a challenge to circular number 135. To Millards, demonstrate very briefly, Millard, what is happening is, Millard, we are exporting iron ore.
Right.
But it is low grade also and high grade also.
Right.
Millards, in case of low grade iron ore exports, there is no export duty.
Right.
When there is no export duty, Millards, on inputs relatable to that, I am eligible for export. In respect of high grade, Millards, when I export, there is export duty. Since there is export duty, government has restricted me under 50 section to claim any refund. So, Millards, what I do is, Millards knows that when I am purchasing ore, there is a direct Millards permit which is issued specifying the percentage. So what I do is I clearly maintain records as to what is the credit relatable to low grade and what is the credit relatable to high grade. And when I file the refund claim, I give that detail very clearly that I am only claiming refund pertaining to that which pertains to low grade.
Okay.
Now, what the officer does is, rather than going by my data, he straight a percentage, even though there is a 1-to-1 correlation. Number two, my lord, what he does is, if the supplier, my lord, in some month, for example, he delays in filing his return, or there is some mistake done by him at his end, he denies me the refund altogether on the strength of these circulars, which say that if there is a mismatch, we will not grant you refund, without doing any scrutiny, my lord. That makes, my lord, the provisions of this rule completely ultra vires the provisions of the statute. Then, my lord, what happens is,
Yes.
yes, my lord. Then what happens is, my lord, the government at that time had also given a leverage that rupees of credit is matching. Then you can claim.
But we are still at the initial stage. I think we'll issue notice.
Yes, my lord. Yes.
And have it along with that other matter which you were mentioning.
No, my lord, that my lords have already heard. My lords have to pass orders in that.
Oh, on that one. Okay. But here there is only, because I'm noticing your stay application.
Yes, my lord.
It's only challenging the circulars and the rules. There is no order or show cause notice or nothing.
Order is already passed. So therefore, my lords, as such, nothing is to be stayed, my lords.
All right.
Because after all, this is to be ultimately, if my lords are to allow my petition, then refund is to be allowed, my lord. So in that sense,
see, there is a show cause notice. Just come to your prayer clause.
Yes, my lord. There is a show cause notice and an order also. Both.
But separately.
Order is impugned, my lord. My lord would find at P35, page 445.
Right. So order rejecting the refund.
That's right.
Right.
Partially they have rejected, my lords.
Or we say notice.
Lord, I am appearing for Lord 5 in this first matter.
All right.
And second matter, Lord, I am appearing for 2.
All right.
And all that state, he has challenged the state rejection order.
He has not been served.
Yeah. Mr. Mishra will accept for 3 and 4. Mr. Satpathy for 5. The GST Council, you will appear for 2.
Next, 2 and 5 in first matter. And second matter, he has only is 2 because he has not made part in.
Okay. 2 and 5. Union of India will be who?
Just Mr. Paddy.
Mr. Paddy. All right.
Whereas for 3, I'll be accepting.
I'm on behalf of 4 only.
All right. 3 and then 4. And then you say replies be filed within 8 weeks, rejoinder for the next date. 1st May. 1st May. All right.
My lords, if at any stage I would be requiring, my lords, an interim, I'll move an application, my lords.
Correct. So notice on the IA as well. All right.
Deeply obliged.
Okay.
Item 6 and 7 both.
Yes, both.
Item number 8.
But the numbers respond numbers.
Item number 8.
None appears dismissed.
Item number 9.
None appears dismissed. Item 9 is there someone appearing? Naik?
My lord, this matter may be taken up next week on behalf of the petitioner. My lord, yes. On behalf of the petitioner, this matter may be taken up next week, my lord.
Why?
My lord, despite all effort, the file of this matter could not be traced out.
That's all right. Then we'll permit you to revive it, sir. If you can't trace it out. Or we say counsel to petitioner stage, the file is unable to be traced. This was the non-prosecution. Permission to revive it in case he files the file. Right.
Item number 10.
Permitted to withdraw, my lord.
Dismiss this withdrawn.
Item number 11.
My lord, question number C, my lord, at page 7, my lord. Question number capital C, whether the tribunal is justified in sustaining the levy of double penalty under section 9(5) of the Waiting Act, admittedly when the goods was covered under para 30 of the Reliance judgment and 1/3 entry tax was paid by virtue of order dated 3/2010 of the Honorable Supreme Court.
Your lordship has already decided.
No. My lord, actually, when the tax due was computed, there was no liability. That man, the Reliance judgment was covered. So my most respectful submission, your lordship kindly para E, my lord, question of law, whether the tribunal was correct in upholding the levy of double penalty in view of order dated 11/2/2000 last in WPC number 630 of 2000.
No, the order is Supreme Court's order.
This court order, my lord. Your lordship may kindly come to para 27.
Let a copy be served on me.
Copy already solved. Read me some copy. Already solved.
Mr. Mahanti,
My lord.
Supreme Court's interim order dated 3rd February 2010
My lord.
has been followed in this.
Yes, my lord. Yes, my lord.
Petition was disposed of.
Yes, my lord.
So
Yep.
you mean to say that this petition, which is disposed of by virtue of order dated 11th February 2016.
My lord, by virtue of this order, by virtue of this, your lordship's order, I was granted 1/3 payment of entry tax. So was not ascertainable, and the learned officer has levied double penalty. Your lordship can kindly seek this court's order.
All right. You say, Mr. Mahanti, learned counsel, the petitioner submits that the present case is covered by the judgment of this court in Reliance Industries Limited versus State of Orissa, 2008-16 VST 85 bracket ORI, which in turn was passed by virtue of the order dated 3rd February 2010, passed by the Supreme Court of India in IA number 327-651 in SLP bracket civil bracket number 14454-14778 of 2008 bracket State of Orissa versus Reliance Industries Limited bracket. You say notice, Mr. Sunil Mishra accepts notice on behalf of the opposite party. Reply within 8 weeks, rejoined up for the next date. List on 2nd May.
Lordship, it is revision. Lordship, it is a revision petition, sales tax revision petition.
Yeah.
Yes.
Reply.
Oh, if you don't want, of course. So, we got that reply part. All right. List on 2nd May.
Item number 12.
My pleasure, Lordships.
Yes, please.
I am withdrawing this petition. I have settled under the Vivad Se Vishwas scheme.
All right. Appellant states that the matter has been settled under the Vivad Se Vishwas scheme. Vivad Se Vishwas scheme. Accordingly, the appeal is disposed of as withdrawn. The memo at flag X is taken on record. All right.
Item number 13.
What's the delay?
May I please know? There is a delay.
34 days. All right. What's the
34 delay, my lord, on the ground of COVID-19 and
right?
by
Right,
WhatsApp.
right.
Yes.
The delay is condoned.
Yes. Lord, here the question is, Lord, is appeal memo page 9. My lord, addition has been deleted by the first appellate authority and the tribunal approved the first appellate order. Rupees 4 crores 12,031 15. My lord, credit and favor some company, my lord. This company, my lord, in this time, in the period of assessment, has not filed in return. And this issue has been, Lord, if your lordship see the order of the tribunal and the invoice which has been issued and verified by Assin is not confined to this, my lord, the transaction which has been questioned in this tribunal's order, your lordship.
No, para 10. Let's read.
Let's see, para
10 of the tribunal's order.
Yes, your lordship. Para 10, my lord, the tribunal has quoted the appeal order and held, my lord, this has been explained, which has not been found to be true or false, but untrue and false, but has been rejected only basis of a pre-potent probability. In this case, Mr. Makeway so was given subcontract mainly for civil work, which requires building material. So sand, chips, steel, metal, etc. It is also not disputed that the Makeway Consultants Private Limited has filed a returns of income. The relevant research assessment completed by the EO, as well accepting the receipt, disclosing company so which includes rebill from the company. We also find that EO was not given any finding that Mrs. Makeway Consultants Private Limited has not raised bogus bill in the name of that. Doing any by accepting the contract received disclosed by a subcontractor.
So the tribunal says they did file returns.
But that is under section 148 does not regular return. Your lordship see the.
Does that make a difference? Does that make a difference?
No, that not make a difference. But the fact remains, your lordship see the page 12 of the appeal tribunal's order. The submission of the revenue.
Mere submissions on the finding. See, the AO who went through Makeway's returns did not find any irregularity.
No,
And that has not been challenged by you. That's the point being made.
No, my lord, whether this is the transaction which has been reflected and stated to have been accepted by the makeway, whether this is a correct figure or correct thing is not.
That you did fail to satisfy the tribunal on that.
No,
these are concurrent findings.
Lord, the tribunal accepted the view of the appellate authority without considering the facts which are reflected in the assessment. Lordship, just a minute, Lordship, placing two lines of this.
Yeah.
Lord, running page 12.
Yes.
The assessing officer observed that the entry amount debited the name of the above company was shown payable in the account of assessee and not in a single penny was paid to the company during the relevant assessment previous year.
That's your submission, sir. That's why the point is the finding is company filed a return, AO went through that return, this is scrutiny
and the
assessment.
Yes, your lordship. The next line is not the AO found a subcontractor so and so are not filed return income for the assessment so and so. In the return for the year filed in response to note 148, makeup has shown contracts are so and so in the PL.
Does it make a difference whether it was filed pursuant to 148?
I will not.
All right. You say the question of loss ought to be urged by the revenue in the present appeal, arising from an order dated 16th January 2020 of the IT in ITA number 398/CTK/2018 for the assessment year 2011-12 is whether the ITAT was justified in confirming the order of the Commissioner of Income Tax (Appeals) (CITA), who deleted the addition of rupees 412,30,153 made by the assessing officer (AO) on the allegation that these were bogus subcontract expenses created in favor of Messrs. Makeway Consultancy Private Limited (MCPL) paragraph. The court notes that the aforementioned company MCPL filed its return of income pursuant to a notice it issued to it under section 148 of the Income Tax Act 1961 Act. Full stop. That return was scrutinized by the AO and no irregularity was found vis-a-vis the transaction in question. Paragraph, which is weighed with the ITAT in affirming the order of the CITA, who deleted the addition by holding that the claim of the revenue that this was a bogus entry was not substantiated by the revenue. Paragraph. Having heard learned counsel for the revenue, the court is not persuaded that the concurrent findings of the CITA and the ITAT suffer from any perversity, which requires examination by the court, interference by the court. No substantial question of law as urged arises. The appeal is dismissed.
Item number 14.
The identical matter is listed on 22nd.
No, but you've not taken steps for limitation, sir.
The level 63.
You have to take steps for limitation.
It's due to cover, my lord. I will file.
No,
all the three 26, 27, 28.
but what is the question? What is the question being urged?
153D, identical case has been admitted and listed on 22nd February 2023.
I am appearing on behalf of the respondent.
I see.
26, 27, 28 appeal number.
All right. He appears on behalf of the respondent.
Okay, please, your lordship.
All right, we see. But in those ITS, questions have already been framed.
This is different millards. That is those which have been listed for 22 millards. I may be satisfied if your lordship permits me, millards. This case is, although it is 153D millards, it is a clear case, millards, non-application of mind and lordship in a. Your lordship permit me, millards.
All right, you say just a notice, he accepts notice. copies be served on him. You've already got copies of these?
Yes, sir. Today, sir.
Ah. See, list on, then we'll list it on some other day then.
Yes. Okay.
Ah. No. 3rd May. You say defects be cured in the meanwhile.
14, 15, and 16. Item number 17.
17.
Again, steps not taken, limitation. Defects not cured, sir.
The only short question is
97 days delay. 97 days delay, sir.
Yeah.
See, there is a 97-day delay in preferring the present appeal, and yet for the last 2 years, no steps been taken for curing the defects. Stop. Other defects have also not been removed. Paragraph. With there being no valid explanation for the delay of 97 days in filing the appeal, the court is not inclined to condone the delay. Stop. Consequently, the appeal is dismissed.
Item number 18.
How the questions of law urged are left open for decision in some other case.
18.
18 the same of 14, 15, 16.
I'm also appearing for this.
So 18 same as 14, 15, 16, same order, the same date.
Item number 19.
Possible.
Possible.
Item number 20.
My lord, 20, I'm appearing virtually, my lord.
Yes.
My lord, this is a batch of matter which is posted for hearing on 27th March 2023, my lord. 27th March 2023, along with other matters in the batch.
What is the other number? Give us the number of one of the.
My lord, OTAPL number.
Sir, delay of 1 to 27 days.
No, my lord. In fact, initially a writ was filed, and this honorable court granted liberty, my lord, to file appeal. That is, my lord, what the order of this court is page 127D, my lord. Initially, we filed a petition, my lord, and department filed appeal, OTAPL. Then the honorable court directed to withdraw this with liberty to file appeal, my lord. Then appeal was filed thereafter, immediately.
All right. You say list along with OTAPL 2 of 220. Sorry, 22020 and March 2020. All right.
Item 21.
Your lordships.
21 and 22. 23.
In fact, your lordships, all three of them are similar matter.
Yes.
And in fact, your lordships will find also there is the serial number 24 and 25.
Yes.
That's the department's appeal. That's all arises out of the same order. In fact, departments, there are 2 more appeals also with department, I think before the holiday notices have been issued.
8 and 9.
Now, but of course, the questions have not been admitted as yet.
So we'll simply list them along with that. Issue notice and issue. All right. Say notice in these.
My lord, she will accept copies.
I'll accept copies.
I have already given copy. 24 and 25.
But in NALCO's appeals, you have to serve copies.
That has served, Mr. That was served.
Okay. All these 5 matters, you say notice. And first 3 matters, he accepts notice for the department.
May, my lord.
Next 2,
all
he
these analogous matters.
Respond.
3rd of May, my lord.
All right. List on 3rd May along with
3rd of May.
2000.
OTAPL number.
OTAPL 8 and 9.
And 9 of 2020.
8 and 9 of 2020. All right.
My lord, in item number 24 and 25, filing of certified copies may be dispensed with because it is already on.
All right.
And my name in 24 and 25.
All right.
I think similar player in 21, we filed the certified copy and the rest of them are dispensing.
All right. IAs are allowed. Okay.
24 and 25.
All right.
My appearance may be recorded in 24.
Yes.
Item number 26.
26.
May I please your lordship?
Yes.
So
I
far
is
as the
allowed,
defect is concerned, it may be, your lordship may kindly be ignored. There is a provision of law which has
All right.
already been mentioned in the cost regime.
All right, all right.
And I filed a miscase for this.
Have allowed.
Madam.
Yes, come now, it's come.
My lord, the question of law, if your lordship will come to page 16.
Yes.
Under the facts and circumstances of the case, when the respondent company has cleared the goods at a lower price to its two sister concern and consequential abundance of duty which is in the mutual interest of the three companies. Therefore, whether the tribunal is justified by holding that such transaction does not constitute a mutuality of interest to the extent of the requirements of section 4(3)(b) IB of the Central Excise Act 1944. Whether and circumstances of the case, the financial accommodation by way of charging lower value among the interconnected undertaking does not constitute a mutuality of interest to the extent of requirement of section 4(3)(b) IB of the Central Excise Act. Under the facts and circumstances of the case, whether the tribunal is right in holding that both the so-called notices are barred by limitation as contained in section 11(a)(1) of Central Excise Act 1944. Well, the brief fact of the case is that the present respondent.
The 11 is time arises, sir.
Kindly come to the tribunal order regarding time burden. It is at page 27, running page 27.
Right.
Para 11. We also find that the demands of duty are barred by limitation as the so-called notices were issued beyond the prescribed period of 1 year as contained in section 11(a)(1) of the Central Excise Act. Necessary declaration in respect of related party transaction in terms of the Companies Act were made in the annual report with the holding of the key managerial personnel. The said annual report were available in the public domain since the appellant company is a public limited company. So what the learned tribunal has said that it is available in the public domain, therefore extended period of limitation will not be applicable.
Right.
Your lordship, here extended period is applicable because they have not declared that one to the department. It has not come to the notice of the
department. If it's in the public domain, we're supposed to be declaring it. We're supposed to be declaring it's in the public domain.
My lord, under the Central Excise Act, they have to declare. The assessee has to declare.
No, he has not. Don't. You're making it positive. There has to be a suppression of facts. The wording of the section is there has to be a deliberate suppression of material facts.
By not declaring that.
No, it's put in the public domain.
My lord,
the onus shifts to you to show there is a suppression. What have you done to show that there is a suppression?
My lord, they have sold undervalued goods to the sister company.
Declared, sir. So
it is declared in the public domain, my lord. That is the fact.
Then where's the question of suppression? Unless you say no, what is shown in the balance sheet is not.
But that has not been declared to the department. It has
question of declaring to the department.
It has only come to the knowledge of the department during an investigation, my lord.
Yeah, public at large. You see, among the several questions,
that fact has been discussed in the first appellate authority order also. If your lordship will come to page 47, my lord. Running page 47, para 11. Your lordship got it?
Yes.
From the allegation made in the so-called notice regarding the suppression of the fact, the defense reply submitted by the assessee, I find that the material facts regarding the undervaluation price fixation have been suppressed from the department. Though the names of the buyers, the values are mentioned in the invoices, they have not submitted the same to the department.
This is overlooking the fact it's in the public domain. It's part of the annual report. The officer seems to overlook that fact. You see, among the questions urged by the department in the present appeal, arising from an order dated 6th February 2020, passed by the Customs Excise Service Tax Appellate Tribunal, the tribunal was in error in holding the notices issued to the respondent SSC under section 11 capital A of the Central Excise Act 1944 bracket CE Act to be time barred, as there was no material to show there is any suppression of information regarding transaction of the respondent SSC with two buyer companies. Paragraph. The perusal Sistat or is the tribunal reveals that in the annual report, which was in the public domain, necessary declarations in respect of related party transactions were made. Full stop. The department was unable to dispute that the said report was indeed available in the public domain. Full stop. Accordingly, the tribunal held that there was no positive suppression information regarding said transactions by the respondent SSC. Paragraph. Mr. Satpathy Lanadi, Senior Standing Counsel of the Department. Sorry, Mr. C.H. Mr. Leonard, Senior Standing Counsel of the Department, has referred to the order of the First Appellate Authority, which is held otherwise only on the ground that the SSC did not make a declaration specifically to the department. Paragraph. Once the annual report containing the declarations was available in the public domain, the onus shifted to the department to show that there was, in fact, suppression of material information by the SSC in regard to the transaction question. Full stop. The department, in the considered view of the court, was not able to discharge that burden before the tribunal. Full stop. There was no requirement, once the annual report of the company of the respondent SSC was in the public domain, for the SSC to again make a specific declaration to the department. Paragraph. Consequently, the court is not persuaded that any substantial question of law arises for consideration. The appeal is accordingly dismissed.
Item number 27.
In this case, my lord, I am appearing for the respondent. I was on caveat, my lords. The appellant have to serve a copy upon me. And the larger issue here is relating to the availment of Senvat credit on clean energy cess. That is a levy which is imposed on importation of coal. And the larger issue is now pending before the Honorable Supreme Court. Yes, in the case of Sri Renuka Sugars Limited. I am just giving the latest status.
Okay.
I am appealing the
all right. Concept of the respondent appearing on advance on caveat informs the court. What is this delay? Delay is how much?
Delay due to COVID, my lord. 20.
All right. The caveat petition, you say in view of the counsel appearing for caveator, this caveat is discharged. IA, for the reason stated, this IA is allowed. And IA 32 of 2020, that is also allowed. In the main appeal, you say counsel appearing for the respondent caveator has placed before the court a copy of an order dated 25th July 2022, passed by the Supreme Court of India and CA number 1531 of 2016, bracket, Commissioner of Central Excise versus Messrs. Renuka Sugars Limited, bracket, and submits that the issue involved in the present case will have to is similar to the one pending the aforementioned case, and therefore this court would have to await the decision of the Supreme Court of India in the aforementioned case. Paragraph. Adjourn Sanadai with liberty to the parties to mention for listing after the disposal of CA number 1531 of 2016 by the Supreme Court.
Our appearance may be recorded.
Yes.
Our appearance will be.
All right.
And copies
The OTPL.
All right.
Item number 28.
Item number 2. Other identical matters are adjourned to 5th of this month, madam.
All right. We should notice same order. 5th is this Friday.
My
This is what?
On 5th, madam.
Thursday. All right.
In all these cases, your lordship, you should notice.
Same date.
My lord.
Then it's okay. It's already coming out on that date.
On the 5th.
Then we don't.
Item number 29.
None of this.
Item number 30.
That is this public interest litigation.
That you've not made a representation, sir. That's a defect 22.
But Lordship, kindly see Lordship, page 37, person Lordship's direction. They rework the entire exercise for
It's all over, sir. This petition we already disposed of.
But Lordship, see one aspect, Lordship. They eliminated the entire tribal resolution, Lordship, which is never permissible on the eye of law, Lordship.
It's all over, sir. Now this whole matter is over.
But they will repeat, Lordship, in
When
future.
they repeat, you file a fresh petition.
Then Lordship, kindly with that such liberty, Lordship.
Prayers having been rendered infructuous on account of subsequent developments. Liberty is granted to the petitioner to file a fresh petition if any cause of action arises. Petition is disposed of.
Lordship.
Item number 31.
31, my lords. There are 2 ODI annexes, my lords. We'll clear the defect, my lords. This may be listed next week, my lords.
That representation.
Not to disperse the compensation.
Representation is at Annexure 6, page 49.
Some OA is already pending. You should ask for a stay in that OA.
My lords.
Why come in a separate petition for that? And that too, like a PI, makes no sense.
Plus, there's a
The affected party should go there, sir.
There's a representation also at Annexure 6.
No, but why all this? There's a pending matter, you go in that matter, seek an intervention or whatever. There's already pending OA number 2 of 2022 before the Additional Assistant Endowment Commission at Sambalpur, permitting the petitioners to seek appropriate remedies in those proceedings in accordance with law. This petition is disposed of.
Deeply appreciated.
Item number 32.
Please, my lord. This is relating to the oldest women's institution of Odisha, wherein my lord was pleased to allow the opposite party to take a road, my lord, only for road. But my lord may kindly see.
Your representation is there. The petitioner's representation dated.
Representation dated 12/5/22.
12/5/2022.
Under Annexure 4.
Bracket Annexure 4. Will be examined by the.
And my lord, after that.
No, your representation is made to whom, sir?
To the Honorable Chief Minister, with a copy to all secretary. Which copy to all secretary.
That won't work.
This is
that
not
won't work,
sir.
sir.
My lord, this
Which kind of representation will not work?
My lord, this issue was earlier raised before.
My lord, that time
with a reasoned order. And again, we are taking.
No, my lord.
Just beauty.
My lord, may kindly see.
Lord Chandi Temple.
My lord, may kindly see page 94-95. My lord's order. My lord allowed the authority to take a road, my lord. Only for road. My lord particularly said, in other words, this portion of the land is being used only for expansion of road. But my lord, in the name of road, they are taking out 72 feet, my lord, 73 feet, 22 meters, my lord, by which the 110 years old Women's College of the Kotak City, my lord, that will cannot be
already covered in government
no,
land.
not covered, not covered.
Non-government land. That was decided.
No, my lord, not covered. No.
Ms. Jena appeared.
Yes,
Yes, my lord. That was the other point. My lord, I want to ensure my lord's order I want that my lord's order should be implemented. My lord directed, my lord may kindly see my lord's order, my lord. My lord's order may.
But the record of government land.
My lord, my lord, no, my lord. My lord may kindly see 94-95, my lord. My lord's order, my lord. I want implementation of my lord's order. They are flouting my lord's order.
Then you go
in the name of taking advantage of my lord's order, as because my lord not directed, not mentioned how much road they will take. They are taking out 73 feet road, my lord. From Madhubabu land, with the architect of this Odisha, my lord. This is injustice to Odisha, injustice to Cuttack, and injustice to our heritage, my lord. My lord directed that only they can take some land for expansion of road. My lord, in the name of taking it for expansion, they are taking out 73 feet road, my lord. Which is, my lord, which cannot be the intention of this honorable court to allow government to take Madhubabu land. But there are 3 types of land. One was gifted land by Madhubabu, another was purchased land, another was the land owned by some other man who lost in Supreme Court, and that land was given by the honorable governor of Odisha in 1975 to this college, and my lord directed to compensate 5 acres of land. But that land is also being construction is going on in that land. My lord can see page 102 in Odia, that land which are proper to be given to this college. As per my lord's order, some other construction are going on. And my lord also, the other land, about 900 square meters land was to be given from plot number 47, has not been given. No construction made. Sorry, they are violating my lord's order. My lord, the Odia people, it is a pride, it involves the pride of Odia people, my lord. Here, my lord, in the name of extension of a Chandi Mandir, Madhubabu, the land, his daughter's land, and the adjacent land is being destroyed, my lord, by which there cannot be any university at that place, my lord.
Destroyed?
Yes, my lord. Because, my lord, that is a bow type. Boat, my lord may kindly see. Every day, my lord is going by that side. That is a bow type. My lord, 73 feet, I measured, my lord. Can a road be width with 73 feet? When 15 feet, 20 feet road are on the way, my lord, from Chandin Chowk to Chandi Mandir. Here, arbitrarily that taken because there is nobody to look after Madhubabu.
Grievance in the present petition is
and also to make it university my second player. 2 players, I have 2 players to implement my lord to ensure the protection, expansion of my lord's order and to consider the upgrading it as an university.
That is a separate thing. So don't combine.
Yes, yes. My representation was on 2 grounds. My representations were made in May, my lord.
One writ petition like this for 2 different disparate things, sir.
And I think that is become already university.
No.
Oh, that's
a different issue altogether. That's a completely different issue, sir.
Here, in the name of expansion of Chandi Mandir,
2 disparate issues are sought to be combined. One minute. 2 disparate issues are sought to be combined in this writ petition, which is projected as a public interest litigation. One concerns the upgradation of the Sailabala Women's College into a university. As far as this prayer is concerned, the petitioner states that the petitioners will seek other appropriate remedies available to them in accordance with law. Separate proceedings. As far as the second issue is concerned, namely non-implementation of the order dated 19th July 2022 passed by this court. Again, it will be open to the petitioners to seek other appropriate as are available to them in accordance with law.
My lord,
my lord, accordingly disposed.
My lord's order at page 94-95 allowed them to take some land for road, but my lord did not clarify how much land they can take. They cannot take the entire land in the name of road. They have taken 73 feet. Let them take 15-20 feet land, my lord, because my lord in the public interest. But a land of 73 feet, both type, my lord. 73 feet, I am measured, my lord. 22 meters.
That has been done. Okay.
My lord, once there was a writ petition when in 92, when Biju Pandya was chief minister, there was a construction in Kendrapada medical campus. At that time, Honorable Justice D.T. Nanavati, Chief Justice was here. He directed to demolition, and that was demolished, my lord. Here, my lord, in a public property meant for education, gifted by somebody, and some land was added by government, only added. But now, once they are taken in 1975 during emergency, one governor of Odisha, he made that arrangement for giving entire land to the Shalwa Women's College. And out of that land, 73 feet land they are taking arbitrarily, my lord. My lord, can people of Odisha be silent when Madhuabut land is being destroyed, my lord, in the name of improving Chandi Mandir, my lord? Millions of people from this women's college, when Prime Minister of India, Pandit Jawaharlal Nehru appreciated that, when Mahatma Gandhi taken rest in that place, when Utkala Sammelan was held at their land is 73 feet, a bow type. My lord, may kindly adjourn this matter and to have a glimpse, my lord, a bow type land, not a straight line.
All right.
I don't know, it is whose brainchild destroying an institution which is 1 or 10 years institution, my lord. So if my lord will not protect and my lord's order is being violated, my lord may clarify how much land they can take.
Yes. All right. Thank you.
Item number 33.
My lord, I will approach regarding university in another matter.
My lord, for removal of encroachment for the public road, the representation page 38 is addressed to the Tahsildar, OP number 4, my lord. Page 38, through registered post, we have approached by the annexure 7. As well as also, my lord, to the collector and sub-collector, because the public road is being blocked by the several encroachers. They are named in the cost title.
6 to 30. All right. The petitioner's representation be examined by the Tahsildar. Soro, opposite party number 4, and after notice to the petitioners as well as opposite party 6 to 30, and after giving them a hearing, the reasoned order shall be passed not later than 1st May 2023, and copies be made available to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Obliged.
Item number 34.
May I please? That the petitioners have given a representation relating to the Sairat of Jambira River in the district of Moirmont, my lord. That has not been considered. Annexure 1 series is the representation on 11.5 and.
So the Tahsildar has to go with import.
No, my lord. Collector opposite party note 2.
The petitioner's representations shall be examined by the collector, Mayurban, bracket opposite party number 2. And if notice to the petitioners and giving them a hearing, the reasoned order shall be passed not later than 3rd April 2023 and be communicated to the petitioners within a week thereafter. The court clarifies.
We do not know what is the status of that in Sairat. So if it is already leased out, he will hear the lessee also. After hearing the stakeholder,
and after hearing the petitioners and any stakeholder.
Yes.
If and the stakeholders, if any. Right.
Item number 35.
My lord, my representation, page 15, annexure 2, pending before OP number 3, regarding encroached by the unauthorized encroached by the encroacher minors.
Who are these?
I have given the details in the representation, my lord.
Where is that?
That is page 15, my lord.
Let's see what details you given.
My lord.
You give the names of the encroachers.
Yes, there are names.
All right. The petitioner's representation, bracket annexure 2.
Tahsildar Bhandari Pokhri.
Will be examined by the Tahsildar Bhandari Pokhri. Party 3. And after hearing the petitioners as well as the encroachers named in the representation, a reasoned order shall be passed not later than 1st May 2023 and shall be communicated to the parties within a week thereafter. The court clarifies it is not expressed.
Item number 36.
Public.
May please, Lords. But here, the pursuant to public notice under annexure 1, Sarpanch and PS member of Amrutya Gram Panchayat have filed objection under annexure.
They have filed the objection pursuant to the format notice in time. That is also, that will be considered. Why?
Let that be considered, Lord.
That will be considered.
I have a petition for that.
The Lordships have direct. Because here, Lord, I am challenging. I am challenging the public notice on the ground. Lord, I am challenging the public notice on the ground. There is no hotel at all.
No, objection will be.
Sarpanch has stated there is no hotel at all. In spite of that, they are processing also.
This is not the stage of examining merits, sir. You filed objections, that has to be considered.
Yes,
No,
if
that your
it's
lordship-
not considered, then you can file appeal or.
By giving an opportunity of hearing, lordships have directed. In similar matter, lordships have
Petitioners
directed.
have already filed objection, public notice. Pursuant to the public notice issue,
Annexure 1.
to stop those objections will obviously be examined, comma. Those objections, comma, if filed within time, comma,
Yes,
will
it is within time, Lord. All in.
will be examined by the
Appropriate authority.
By the collector Jasper.
That is.
by the
Collector
collector
Jasper.
judgment in accordance with law. No further directions are called for from this court at this stage.
By giving a lot of opportunity of hearing to the Sarpanch and PS member.
We don't
Because
know if
Lord, they are
that-
people's
If
representative,
that
Lord.
Collector will.
Lord, they are
procedure
people's
is available.
representative and the lordships have directed. I have given also. By giving a
Let's not go
personal
beyond the
hearing.
statute, sir. All right. Yes.
Item number 37.
On behalf of Mr. Samajit Raut, my lord, pass over the matter.
All right.
Item number 38.
Pass.
Item number 39.
Lord, item 38 to 41, my lord, I may be permitted to remove the defect within.
All right. Defects will be removed within a week. List thereafter. 38 to 41.
41, my lord.
Item 42.
Well, I may be permitted to only one.
Same order.
42 and 43.
Okay. 42, 43, same order.
Item 44.
44, my lord, I may be permitted to remove the defects. Let it come next week, my lord.
All right. Same.
Item 45.
Well, remove the defect in course of the day.
All right. Same.
Item number 46.
My lordship. My lordship, this is a case regarding service tax for the financial year 2015-16, and order has been passed, and we are challenging jurisdiction as well as the principle of natural justice not being followed, my lordship.
That will go on appeal, sir.
My lordship,
remedy available.
we are challenging the jurisdiction, my lordship.
So what? Even that can be challenged in appeal. There's no problem at all.
That would not be an efficacious remedy,
No,
my
no.
lordship.
Why do you say that? Permitting the petitioner counsel, petitioner seeks leave to withdraw the present petition with liberty to file an appeal against the impugned order in accordance with law if such appeal is filed not later than 6th February 2023, accompanied by an application for condonation of delay citing the pendency of the present petition as the reason for the delay. To be considered in accordance with law by the appellate authority. The court clarifies it is not explicit in any matter.
Lord, I am appealed 2 to 5 in this.
All right. The petition is disposed of.
Item
My
number
lordship,
47.
4 weeks time may be given.
And we've said 6th February. Sir.
47.
Item
47,
47.
I'll remove the defect in course of day, my lord. Let it come day after tomorrow. My lord.
No, next week. Defects be removed within a week, list thereafter.
Item number 48.
48, your lordship, we have removed the defects. Kindly keep it to next week.
Defects be cleared within a week, list thereafter. All right.
47, I'm serving copy just now, my lord. This.
All right. What's the matter about? Tell us then, what is the matter about?
That is what I think that is against state of Orissa, not state GST. But you are solving the copy to the state GST.
One of the party, I will serve copy, I will another copy also.
Then in that case, see. Defects be removed. All right, list thereafter.
Item 49.
Lord, I may be permitted to withdraw with a liberty to file a representation before the authority for consideration.
All right. Petition seeks leave to withdraw the liberty to make a representation to the concerned authority in accordance with law. The petition is disposed of, liberty is paid for.
Item number 50.
Not 50, but annexure 1 under annex at page 12, it is under challenge. Now here the government has rejected the grant of on license without assigning any reason. And Lord, that apart, the notice was issued to give me for a hearing, and prior to that, this order has been passed. Under annexure 10, 36, Lord, hearing was given. This is the notice. 26/10. And my appearance was on 7/11 for hearing. Order was passed on 10/10/2021. And also this order has been passed without assigning any reason.
Then order was 15th November. Sorry.
No. The impugned order is 10/10, Annexure 1. Prior to my revision, petition is pending. Without considering that, this impugned order has been passed.
No, the revision case, Annexure 2 at page 13.
That is different thing. That is the second part, that I have filed revision. He heard me, and on the ground of mental limit, it was rejected. And I am challenging. When my revision was filed on prior to that on 10/10, how can I reject this?
Notice, Mr. Mohanty accepts notice for opposite parties.
All the opposite
parties.
But not similar matter, lordships have set aside on the ground that it is not assigned reason and giving an opportunity to the state.
Let him examine the matters. Till the next date, no coercive steps shall be taken against the petition.
Lordship may fix a short date so that it will be disposed of. Short point is there. The Lordship's order is there. Remanding the matter to the secretary to again decide and give an opportunity to hearing. If Lordship will pass that order also, it will suffice.
Item number 51.
Item number 51, so far as the first item is concerned, that has become infractious.
All right. 670/2015, disposed of as infractious.
In view of the first order, my lord, the second item is also infractious.
All right. In view of the above order. Writ appeal 730/2015 is also disposed of the same terms. All right.
Item 52.
52, my lord, I am in the contempt. The order was in the favor of the petitioner, writ petitioner.
All right.
The writ appeal has been challenged.
The petition 52, that first item, none appears for the appellant. 203, paragraph. In view of the order passed today dismissing writ appeal 203/2016, the order of which implementations, you say the present petition is disposed of with the direction to implement the order in question of the learned single judge positively within 4 weeks. The contempt petition is expressed.
Okay.
Item 53.
53, state is the appellant.
415 days.
Delay, but the important matter is very important. This is regarding CR zone.
Regarding?
CR zone in Puri, near the seashore, how the hotels will be established. This is Puri session filed the writ petition that was allowed to challenge. If your lordship will simply issue notice, then the matter can be.
No. What is the prayer granted? What is the
impugned order at page 151. This is a writ petition filed by the Hotel Association of Puri, represented through its president, so challenging the inaction of the state government and Puri Konak Development Authority in not allowing the construction activities within the prescribed norms of coastal regulation zone to herein sought CR town of Puri. After the Puri town has been declared to have come under the CRZ 2. The petitioner also asserts the jurisdiction of the PKDA insofar as the provisions contained in Orissa Development Authority Act so and so is in view of the 74th
But
amendment.
it's surprising, sir, if it is so important, you didn't even bring it up for hearing once. It was listed once on 10/11/2017. You prayed for 10 days to make good the deficiency. That also has not been made good. We leave it open for consideration some other problems. A whole batch of appeals. No? Maybe an entire batch. So something must be in time. This is one appeal which has gone beyond time. They only said the government has no jurisdiction.
Yes,
Coastal zone regulating authority is competent. So it's not that they cannot do it.
With that observation.
You say there's an inordinate delay of 415 days in filing the present appeal, which has not been properly explained. In view of the decisions of the court in Living Media India Limited and State of MP versus Berulal, the court is not inclined to condone the delay. The application for comment paragraph. Accordingly, the writ appeal is dismissed, leaving the question of law urged open for decision in some other appropriate case.
Item number 54.
None appeals for the appellant dismissed.
Item 55.
Same order.
Item number 56.
On from virtual mode, but I pray, let it be taken up 2 weeks after.
Why?
But I have to file an affidavit. I could not be able to file. But I pray, only 2 weeks time. Maybe.
No, what were you supposed to file?
But your lordship directed to take instruction whether the appellant is continuing. I could not be able to take the instructions. I pray only the 2 as in a last chance, 2 weeks after.
You must have found out who's for the respondent. No one's for the respondent.
Respondent is the private party. Respondent number 1. I'm a little difficulty. That is why I pray as in a last.
All Anganwadi workers as a thing.
It is
legal. We keep adjourning these kind of matters. Not
this.
These are not those kind of matters we should keep on adjourning like this.
Only one chance,
No, it's all right. It's all right. More than 2 months. Oh, more than 2 months have been given. That's more than enough. The consular appellant has still not been able to take any instructions pursuant to an order passed on 3rd November 2022, 2 months ago. The court therefore does not propose to grant any further indulgence. Defects have also not been cured for almost 4 years. The writ appeal is accordingly dismissed.
Item 57.
My lord, in this case, an UTP has died in jail due to snake bite. The submission is made that the jail authorities has the responsibility to maintain proper hygiene and safety measures.
These are all factual matters, sir. And you see, the present petition concerns an incident which is supposed to have taken place more than 10 years ago. It is not possible at this distance in time to order even any inquiry into it. Consequently, the court is not inclined to in the present petitions dismissed as such.
Item 58.
My lord, kindly give me one chance to refer Annexure 6 in the rejoinder, my lord. Actually, for death of snake bite, 4 lakh rupees is paid at ex gratia by the state government.
It has to be first found out, sir, whether he died of snake
recently.
bite.
So
the fact-finding inquiry. It can't be just ordered like this.
Snake bite already admitted, my lord. Snake bite already admitted by the state, my lord.
There is no document filed as far as this admission is concerned.
Yes, admission report, everything has been filed by the prison authorities, my lord. State government has filed death due to snake bite.
After 10 years, again issuing notice, but for the first time it is listed, I think.
No, he was himself playing with the snake. Just look at this para 4.
My lord, all these things are mentioned.
Disputed questions are facts, sir. Or did you take this?
But there was no proper inquiry
alleging that an inmate in prison died out of a snake bite and therefore should be compensated in terms of the extant scheme prepared by the state for such purposes. Paragraph. In the counter affidavit filed, the state denies any negligence on its part. To stop the precise averment reads as follows. To take the whole of para 4. My God. He swallowed the blood. In view, the full stop. Clearly, therefore, in the present case, it is not possible for the court, in view of the above factual finding during the inquiry, to grant the relief as prayed for. The writ petition is dismissed.
My lord, the ex gratia amount may be considered by the state government.
No, sorry, sir. Yes.
Because the petitioners are minor daughters, and after the death of their father, their father also abandoned them.
Not in these kind of cases. Sorry. Yes.
58.
Let's say this CMPL is for restoration of the writ applications dismissed for default due on 27/10/2022.
I want a written apology for this absence. People like you, Mr. Rath, if people like you start following for this.
My lord, I'll endorse a written apology for not being present there. I said that due to my illness, I was.
No, that's not even correct. That's not even correct.
Well, I think
taking a very firm view on these things. You said that the court is not satisfied with the reasons given in the application. It is dismissed.
Lordship,
No, sorry, sir. Sorry, sir.
Lordship say.
Sorry, sir. Sorry.
Lordship, kindly see this.
The court is not satisfied with the reasons given in this application. The application is accordingly dismissed. Yes.
Item 59.
Lordship has genuine grievance and Lordship.
You people have to think twice, thrice now. All illegal activities of these kind of things have to stop.
Already in item
The
number
Lordship, I agree.
59.
The next date I was there, but that date I was feeling bad and I could not. The Lordship, on the next date I have.
So the hybrid hearing is going on. There were many lawyers appearing. We've passed many orders. Lots of matters. Orders have been passed disposing of writ petitions.
Lordship, just pardon me.
This is a risk. This is a risk you choose to take.
Lordship, pardon me for this one.
Old habits have to change, Mr. Ratha.
My lord, this one day,
We have to be serious about our profession. We have to be serious about our courts. We have to be concerned about litigants.
My lord, I beg apology for that. No, Lordship, this is a lawyer mistake. Lordship.
Not first speak the truth in the application, then tender a genuine apology, that will be considered. If you want to withdraw this application, you withdraw it.
My lord,
Counsel for the petitioner seeks leave to withdraw this application with liberty to file a fresh application in accordance with law. Disposed of is withdrawn with liberty as paid for. Let's see how truthful you are. Yes.
Item 59.
Already in item number 59, I am supposed to file the affidavit today. Last chance I am seeking. Last chance.
I'm appearing for the Central Pollution Control Board, my lord.
Last chance because there is some miscommunication from our office. Any short date will suffice.
As a last chance.
Yes.
The Constable State is permitted to file the affidavit in terms of the order dated 23rd August 2022 on or before 6th February 2023. List on 14th February.
Item number 60.
60, my lord, pursuant to the.
In this case,
I have served the copy to my register.
they have filed this is the beautification related to paternal. This that is they are the beautification maintenance and cleanliness of the paternal. My lord, they have simply filed an affidavit. You lordship directed to comply. Directed who is the authority to make beautification and drainage systems. There are so many government agencies. One CDA is there, another is Drainage Division and Irrigation Department. Now, Drainage Division are given an affidavit that they have approved 36.13 crores for beautification, but they have not stated the modalities in which way they will float tenders. What are the works they have to make done? Nothing. Only for beautification, we have floated tender, and within 18 months we will complete. In the meanwhile, 2 months already elapsed. Nothing has been done. Milord, your lordship direct, they should give the modalities in which way the money shall be utilized and who are the authorities to take the responsibility of those paternals throughout the years, Milord. What are the money to be spent for beautification? What are the money for maintenance and cleanliness and the upkeep of the paternal?
You have the photos of the paternal.
Yes, yes.
Where is that?
Last occasion also.
Peternala. Where is the photos of the peternala?
These are the garbage still lying.
What's the date of this photograph?
Milord,
what is the date of this photograph?
2 months back, I think.
Not so casual. Just give it back. Don't be so casual, sir. You're serious about this petition, no? Give us a recent photograph. It takes nothing on a mobile phone. People can take photographs. Please be serious. Please be serious. The petitioner seeks time to place and record the latest photographs / videographs of the peternella.
Mirror.
At his request list on. When will you do it, sir? List on 17 January.
Mirror. And in the meanwhile, they should submit an affidavit. The money in which way the utility.
First do this, then we'll tell them what
last week of the January.
27 January. All right. 27 January. All right.
Item number 61.
May it please, your lordship.
My lord,
My lord,
item 61.
Order dated 15th of September 22. Your lordship had noted my contention that there is a stalemate prevailing in the ORERA where it is not executing its orders. The rule provides that it has to execute as per the civil code.
If I may.
And its inability, it has to send it to civil court where the property relies outside the jurisdiction of the court. And your lordship directed both the ORERA and the state to come with concrete solutions.
As item 61, my lord, is unfortunately a wrong file because the petitioner and the council.
The last chance was given to them even on the last date.
My lords may post it anytime next week. I'll get the file, and probably the counter affidavit is also there.
What about Mr. Tripathi must be the ORERA man?
My lord, we have filed a counter.
No, but you have to sit with the state government.
Well, state government, we have state government. It seems to me that some letters have come to ORERA on behalf of the state government. That is what was my friend was saying.
At the joint request of both Mr. Tripathi appearing for ORERA and Mr. Mohanty appearing for the state, who need some time to place and record the modalities. List on. February 7th.
Well, in fact, the ORERA has filed its counter. It has given no solutions. They have simply said your writ petition is misconceived. It is liable to be dismissed. This is, the authority has either it has to act or it has to perish. It is doing nothing. My lord.
Come over.
Yes, your lord.
All right.
Item number 62.
Item number 62, 63, 64, your lordship. 4 weeks more time may be granted for filing of count.
Final opportunity to file the reply within 8 weeks adjourned for the next date. Interim order.
63, 64, Milords, I appear on behalf of Mr. Acharya.
Interim order to continue this on.
I'm submitting memo of appearance.
All right. All right. 16th March.
Item number 65.
May I please, my lord? 63.
62, 63, and 64.
63.
These are Ms. Roy Chaudhary's matters.
61.
63, 64, Mr. S.K. Acharya.
Mine was 60.
Mr. S.K. Acharya. All right.
Item 65.
More for 63.
Second mistake. 63.
That is the other list. Yes. May I please, my lord?
Yes.
65.
So it's a very voluminous file for lordship. I have.
See, the advantage in digital is we don't know how voluminous.
Otherwise, I would have got wrath from your lordship. I know. I know. It's a 666 pages of brief. Well, sir, I'm cutting it short. As per the latest development that has taken place in the meanwhile, after the last order passed by lordship Milords, there are 16 shipping bills, Milords. That's out of 16 bills, Milords. That's in respect of Milords, which I have received, the order in respect of which I have received, I have filed appeal. Other 14, I have not received the orders, Milords. But in respect of those 2 Milords, now appellate authority has decided those appeals. And I am filing, Milords, a compilation. Your lordship may need not go to all except the relevant one. My lords may now kindly, Milords, see page 80, Milords 87. Page 87. My lords may kindly see shipping bill number in the tabular form, paragraph 001121 IOF 2007-8. Paragraph 001233 IF 2007-8 dated 29 to 2008 Milords. So these 2 shipping bills, now your lordship may kindly see the order starts from page 85 and this is disposed of, and page 100 it refers to a judgment of the Honorable Apex Court in Gangadhar Narsingh Das Agarwal's case, Union of India versus Gangadhar, 88 ELT 673 Bombay. Next, Supreme Court, UI versus Gangadhar 18 and ELT 19 Supreme Court,
And referring to this now, the ordering portion, my lords may kindly see, that is at page 110. At page 110, I set aside the order in the original, number one, dated 25/1/2018, issued from file number so for finalization of both the shipping bills, dated so determining export duty at the rate of so. I order for redetermination export duty at the rate of ₹50 under notification number 62/2007 in both shipping bills, dated so. Because what has happened in this of the entire dispute is, because if the FE content is less than 52%, 62%, because as per 2007 statutory notification of the CBS, the rate of duty is nil. Because if it is more, then it's 300 rupees. If it is less, 50 rupees. Now it's reduced to 50 rupees. The question is, because I have initially, I paid as per the FE content mentioned in the contract. Because in the contract, there is a standard FE content. But payability of customs depends upon the actual determination of. Sorry, exactly, So, department at the time of export, drew sample from the materials which are to be exported, and the export report, the determination report came later, test result report came later. And those materials, those reports are not supplied to me. I have to obtain by FTI channel only, and I have annexed by annexure 4 and 5, the details of test report, and that is annexure 4, page 547 to 559. If your lordship will have a glance, my lords will find that all results are below 62%. Now, Millers, what is required to be done, Millers? Based on that report, Millers, it should be finalized. And the appropriate provision is section 17(4). Millers, now they claim that we have finalized. And Millers, one provision only, after that I will take your attention. Millers, section 153 says, the order has to be served. If at all you pass an order, you claim that you have passed an order, that it is served. I have got only 2 orders, Millers. Rest 14 I have not been served. And section 128 of the Customs Act says, from the date of communication of such order, within 3 months, the appeal is to file. So 2 things are, lordship have to keep in mind. The order which is served, they say it is dispatched. And I specifically pleaded in my replies that your lordship will kindly now turn to Millers.
Why don't we cut this controversy short? We've already lost 8 years waiting for the order.
My lords.
Let them serve you an order now. All these orders, we'll fix a date. They'll serve it to you by that date.
That will be better.
And you file the appeal within.
Right.
All right.
That will be fine.
All right. So the main controversy in the present case is whether the department has served the adjudication orders on the petitioner or not. Paragraph. In 2 of the matters where adjudication orders were in fact acknowledged by the petitioner as having been served on it, it filed appeals which have now been disposed of during the pendency of the present petition.
2 out of 16 minutes.
That's what. As regards department claims, it has dispatched the orders. The SSC claims it has not received the paragraph. In order to cut the controversy short, particularly since 8 years have elapsed in the during the pendency of the present writ petition, the court issues the following directions. 1, in respect of the 14 matters in which the
14 shipping bills, my lord.
In respect of 14 shipping bills, in respect of which the petitioner claims not to have received the orders. The orders in question will be served by the department on the petitioner, positively on or before 6th February 2023.
Some more time.
Just serving copies of the order? Where's the question, sir?
Well, I have no instruction. Just now I am. That's why.
It's a long pending matter. Only order to be. If you have, you can only get it over.
I do not know.
Or 2, within the full stop, for the purposes of filing of the appeals against those orders, the actual date of service of the orders upon the terms of the direction issued in clause 1 above will be taken as the date of service of the order. 3, it be open to the petitioner to prefer appeals against the said orders, if adverse to it, in accordance with law, within the time provided, within time, you say, paragraph. The court clarifies it has not expressed any view on the merits of the matters.
Your Lordship is disposing of?
Yes, yes.
Your Lordship is concerned in terms of the orders already passed and the apex court decision which I rely upon, that will be considered minutes.
Yeah. It will be open to the petitioner to urge all the pleas raised in the present petition on merits in the appeals to be filed by it in the above terms. The writ petitions accordingly disposed of.
Deeply obliged.
Item number 66.
66, I have given a Lordship's order. My Lordship have posted these matters to 25th of April. The connected matters, madam.
Well, it's not necessary to be posted. Can be disposed of by today, my lord. So there is an inordinate delay by the adjudicator. More than 18 years have been taken to communicate the adjudication order, your lordship.
Similar issue, Lordship, I have heard.
Like on 11th of March, 1999, your lordship, the so-called notice had been issued, your lordship. And thereafter, after 18 years, your lordship, there is no action by the department. Only after, your lordship, on May 2000, they issued a notice of personal hearing. This order has not been cumulated more than 18 years. And with regard to the goods which are removed 24 years before lordships, the my lord has been covered by my lord in the case of Muscat laboratory, your lordships. And where the my lord has observed that the order is not sustained across the entire proceeding. Let me share the copy of the order. So compilation.
I'll go through it. Lordship may fix a date, I'll go through it.
It is covered, my lord. Covered, my lord.
On 6/12/2022, Lordships have been pleased to issue notice in connected matters, my lord.
No, those are 2021 matters. Here, this is already an old matter.
Then Lordship may keep
pleadings are complete in this.
May I pray? Lordship may give me some time to at least go through this judgment, my lord. It is serving right now.
It is my lord's order.
Lordship may fix a date, my lord.
Lordship, kindly to glance to page 4 of my compilation, your lordships. Page 4, para 23, your lordships. Specific to the issue of case to and reviewing it after the long gap without any reasonable explanation. There are a decision of the High Court that have been quashed such proceeding in Siddhi Vinayak Syntax Private Limited Supra, and the case sought to be revived after 17 years after initiation of so-called notice. The attempt was negativated. Likewise, in Magmine Organic Limited Supra, the Gujarat High Court invited the attempt to revive the proceedings more than 13 years after the so-called notice. To the same effect, the decision in Swati Menthols and Allied Chemical Supra, when Palla International Limited, Supra, and Mr. G. Supra, this three entities also Supra held, para 24. For all the enforcement reasons, this court finds no justification to the opposite parties to revive the adjudication proceeding after against the petitioner 18 years after the issue of so-called notice. Accordingly, the impugned so-called notice are hereby quashed. The writ petition is allowed, but in the circumstances with no order of cost. My lord, I have shared the date chart, your lordships. The period is 94 to 95, your lordship. In the WPC 11/809, your lordship. The so-called notice issued in March 99, your lordship. Thereafter, 18 years the department kept in silence, your lordship. After 18 years, on 26th of May 2017,
case, sir.
I understand, my lordship. Kindly see page 27.
Let's see what you stand in the counter affidavits.
Yes. Para page 2, para 4, my lord. It was written from the call book on such and such date and adjudication proceeding.
So no explanation at all. This is very clear. Correct. Nothing given. No explanation. Yeah. The prayer in the present writ petition is for quashing of a show cause notice dated 11th March 1999, issued by the department to the petitioner in relation to alleged violations of rules 9 bracket 1, 52 capital A, 173 capital B, and 173 capital C of the Central Excise Rules 1940. Read with section 11 capital A,
My lord.
bracket 1 of the Central Excise Act 1944. Paragraph. The admitted position is that the period for which the demand was sought to be raised by virtue of the above SCN was April 1994 to April 95. Paragraph. For some reason, which is not clear, the case appears to have been transferred to the single court's call book on 28 April 1999. Full stop. Meanwhile, on 18 June 1999, the petitioner replied to the SCN. Full stop. Paragraph. The department then slept over the matter for a long period of 16 years, after which, on 15 July 2016, it was suddenly decided to retrieve the matter from the call book. Full stop. On 26 May 2017, a notice was issued to the petitioner fixing 1st June 2017. Full stop. Paragraph. On 31st May 2017, the petitioner filed a request for adjournment and in the meanwhile filed a present petition in which notice was issued by this court on 14 September 2017, staying further proceedings pursuant to the said notice. So that stay order has continued since. Paragraph. In reply to the writ petition, then explanation, there is no valid explanation offered by the department as to what prompted it to shift the case on 28 April 1999 and then retrieve it from the said call book 16 years later, all of a sudden. Full stop. The precise argument in the counter affidavit in this regard reads as under: reproduce the whole of para 4 at page 44. Paragraph. Mr. C.R. Das, learned counsel appearing for the petitioner, relies on the decisions of this court in MaxCare Laboratories Limited versus Joint Commissioner CGST 2021 378 ELT 401 bracket Orissa and an order dated 24 December 2021 passed by this court in writ petition civil 13195 2000. This Orissa Mining Corporation Limited was the sales tax officer. Paragraph. In MaxCare Laboratories Limited, in more or less identical circumstances, this court quashed the SCN and the further notice fixing the date of hearing. Full stop. In the present case also, the court is unable to find any valid explanation offered by the department in the delay in issuing the initial show cause notice under section 11 capital A of the Act. 5 years after the 4 years after the period of demand, and importantly, taking 16 years to retrieve the matter from the call book. As noticed by this court in MaxCare Laboratories Limited, Supra, in similar circumstances, other high courts, the Supreme Court of India, in Government of India versus Citadel Fine Pharmaceuticals, 1989, 42 ELT 515. In the context of proceedings for recovery excise duties on medicinal and toilet preparations, observed as under A to A. Likewise, in CCE versus Kemfar Drugs and Liniments Limited. 1989-40 ELT 276 bracketed. Supreme Court observed as random. Correct. Other high courts too have invalidated SCNs, where attempts were made by the department to revive a matter sent to the call book several years later. So these decisions include Siddhi Vinayak Limited versus Siddhi Vinayak Syntex Private Limited versus Union of India, 2017, 352 ELT 455 bracket Gujarat, and Megamani Organics Limited versus Union of India, 2019, 368 ELT 433 bracket. The aforementioned reasons, this court quashes the impugned SCN dated 11th March 1999 and all proceedings consequent thereto, including the impugned notice dated 26th May 2017. So the writ petition is allowed in the above terms, no others.
Grateful, my lord. Obliged. My lord, WPS number 11837. There is a slight change in date type charge.
Oh,
the second, I given the date charge, the second page, your lordships.
All right. In the next writ petition 11837, the dates have to change and the period of the matter. All right.
People.
Item 67.
Lord, this is for the license period 2017-18. 2017-18, man. Lord, K. Balu judgment 15/12/2017. 16. K. Balu judgment. And Supreme Court said that along the national highways or state highways. Now, accordingly, they asked me to shift it, my lord. Annexure 3, page 13, your lordship kindly see. They, the 2nd of February 2017, referring to the Honorable Supreme Court judgment, page 13, they asked me to shift this up to some other location. But it was operated in a rural area. Now, I could not find out any location in rural area. I had to shift it to an urban area. So they asked me to give an undertaking, that you give an undertaking that you will pay the fees and for whatever is applicable for urban area. But I have given an undertaking. That is also. But now they have passed an order against me that we deposit the differential amount. My only humble contention is that, Lord, during currency of the license period, despite my undertaking, you can't increase the license fee or MGQ. But this is apparently passed by the collector. I should move the commissioner of.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to challenge the order of the collector. Order dated?
That is Annexure 1.
Annexure 1.
Order dated 11th April 2017, passed by the collector. No, but it's passed
by order of collector. Election is just above that.
That is the district excise office.
Correct. So, before the commissioner of excise in accordance with law. If such appeal is filed not later than
2 weeks time be given.
Okay. 6th February 2023, then the delay on account of the pendency of the present petition will be taken into account by the commissioner. The court clarifies it has not expressed any view in the merits of the matter. Till such time, the commissioner disposes of the appeal. There's an interim order here.
No, there is no interim.
Oh, I see. All right. Then that's so. The petition is disposed of in the above terms.
68.
None appears dismissed.
Item 69.
69 not pressed.
Not pressed. Dismissed.
Item number 70.
Lord, precisely the matter here is, Lord, 1819. There was short supply from the side of the state. They could not maintain adequate stock in their warehouse to be supplied to the licensees. But I have deposited money for the period, whole period. I have deposited the money to lift the liquor, but they could not supply. So some of my amount remained due on them. Some of my amount remained due on them. They could not supply me the liquor.
Thereafter, my lord, they have renewed my license to for the further period. What I am saying is, my lord, since you have to supply me the liquor, despite my deposit is outstanding on you, you are not supposed to withhold it. You are liable to refund it. Rule 151, if Lordship kindly see. Rule 151 says we have to apply the collector with approval from the government. Collector is to consider it. So, Lordship, referring to Rule 15, there is also a set of orders passed by the Honorable Court. Kindly similar. I have also given to my lord.
That order relates to some other exercise thing.
That is
Not
from 12 to 2016-17. Here it is 18-19. But the principle would be same. But keeping that in view, Lordship may permit me, Lord, I'll apply the collector. Collector will hold an inquiry and pass an order.
That can be, but this decision is not applicable. This is for the excise year prior.
Let the collector also consider that. Let the collector
seeks to withdraw the present petition with liberty to approach the collector with a representation with an application for refund.
Yes,
of the deposit made towards duty against the quantity of short drawn MGQ. If such representation is made not later than 6th February 2023, which will be considered by the commissioner, is it?
By the collector.
By the collector in accordance with law, after taking into account all the contentions of the petitioner. And the decision be communicated to the petitioner within a period of 8 weeks thereafter. The court clarifies it has not expressed anything in the matter. The petition is disposed of as withdrawn with liberty spread for and afters.
Lordship only picks up a time limit for disposal, madam.
8 weeks.
Grateful.
I beg pardon, my lord. I have item 19.
Item number 19.
Pass over item 19.
19. That's
19.
19, sir.
19. May please, lordship.
Yes.
The department has come up with the appeal, my lord, challenging the order passed by the Lord Tribunal. My lord, the ground is non-deduction of the tax due TDS, my lord, on section 194H. This matter has already been dealt with by this honorable court. Lordship, kindly see page 31, paragraph 20. Earlier, this honorable court, relying on the order passed by the Honorable High Court of Rajasthan High Court, my lord, there has been challenged for the Honorable Apex Court subsequently by the department. But relying on the said order, this honorable court, my lord, disposed of another appeal against the department.
So
my lord, when that is pending for the honorable Apex Court.
This will also you take it to the Supreme Court. There's no stay of that order.
No.
So we'll follow
that
our
is
order.
Pending for, I was checking, my lord, that is pending for hearing.
That's all right. You can take this also there.
In other orders, my lord,
yeah. The present appeal by the revenue is against an order dated 5th June 2020 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, allowing the appeal filed by the SCC in ITA numbers 306 to 309 /CTK 2019 for the AYs 2009-2012-13. So the present appeal relates to AY 2011-12 paragraph. In relation to other AYs, the revenues appeals have already been dismissed by this court. One such order is the order dated 20th February 2019 in ITA 9 of 2012, passed by this court following the judgment of the Rajasthan High Court in ITA number 205/2003 IT bracket TDS bracket Jaipur versus Messrs. Idea Cellular Limited. Paragraph. Although it is stated that an appeal has been filed against the order of this court.
Yes, ma'am.
Against the above order dated 20th
No,
February.
no, my lord. That order has not been challenged, my lord, due to the limitation, my lord. The monetary limit, that order has not been. But Rajasthan High Court, which has been relied upon, that has been challenged and that is pending.
All right. It is said that although no appeal was filed against the order dated 20th February 2019 of this court, monetary limit, the appeal stated to have been filed against the aforementioned judgment of the Rajasthan High Court in CIT bracket TDS Jaipur versus Idea Cellular Limited bracket Supra is stated to be still pending the Supreme Court. However, there has been no stay of the aforementioned judgment of the Rajasthan High Court. Paragraph. Following the decision of this court dated 20th February 2019 and 98/9 of 2012, the court declines to frame the question and dismisses the present appeal.
Pastor matter item 37.
May I please, my lords? This writ application is in the nature of public interest, my lords. But annexure 1 is the notice by the collector inviting objection to the establishment of on-shop. There was representations.
Same issue. He has lodged objections within time, and before it is considered, he has filed this.
Considering that the petition objections, the public notice dated 29th November 2022, annexure 1 bracket, they ought to wait for the outcome of the said objections. Instead, they have chosen to come straight to this court with a present writ petition less than a month thereafter. That is on 21st December 2022. Paragraph. The petitioners will do well to await the decision on their objections. If such objections have been filed within time as claimed by the petitioners, then the orders on those objections by the collector,
yes, by the collector, it's OP number 2,
Collector Jashpur, will be issued within the time stipulated within the statutory time stipulated. Full stop. No further directions are called for at this stage.
And let me observe that this court is not expressing because
court
they are showing
clarifies
this
that
order
not expressed
that honorable court
any
has.
view on merits. All right. Let's start. The whole court is full.
Weekly running list. Old matter item number 1, OJC 10936 of 2000.
Yes, item 1. The defects have not been removed and the matter is.
All right. For more than 20 years now, defects have not been removed. Even otherwise on merits, the court is not inclined to interfere with the order dated 12th July 1999 passed by the Odisha Administrative Tribunal in over 307 of 1999. The petition is accordingly dismissed.
Item number 2.
Look at order dated 26/9/2022. Mr. Paddy was directed to produce a circular and he is yet to obtain instructions from the MOEF. And the state was asked to obtain some notifications. Paragraphs 4 and 5.
Mr. Paddy, where are you? We'll pass it over once.
Can it be some other day?
The only thing he won't know, and then he'll again take time on that next day also.
No, if your lordship keeps it to some other day in this week.
All right.
And as Mr. Mahanti obtained notification,
then we'll just keep it on board then, but because he should come on, he should participate. Otherwise, What about this? You were to,
Lord, so actually, for the first time, this file is interested because it was dealt with by another government advocate.
or that we'll shift it to the other list then. You say, while Mr. Manthi, Mr. D.K. Manthi, seeks some time to seek instructions pursuant to the order dated 26 September 2022. There is no appearance on behalf of the Union of India. Full stop. In the interest of justice, list on February 2023 in the regular list. What?
28th February.
28.
Item number 3.
Database dismissed.
Item number 4. Item number 5.
Database dismissed.
Item number 6.
Database dismissed.
Item number 7.
May kindly have the order dated 5th of July 2022. There your lordship directed for a submission of a factual status report.
What happened?
Yes, madam. Yes, that report is perhaps.
Whether he's still remaining cultivating position.
Yes, madam.
The Tahsildar was to visit the site.
The Tahsildar's report is there. Yes, madam. Should I place that report? Very short report. In compliance to the order of the Honorable Court, I visited the site, case land pertaining to plots on the local RI Patrapada was present during my inquiry, also with relevant ROR, village map, and proper identification of the land in question. After proper verification of the records and village map, it is found that the suit land in question is coming well within the AIMS campus, and no access to this plot is available from nearby public roads. Further, the suit land is found lying open without any boundary around it, but that exists one small house of brick wall with asbestos roof and another mud wall with thatched roof, which appears to have been recently constructed in order to prove the possession. No electrification, water supply is available. Yes, I will file
copy of the Tahsildar.
Filing, since the date of filing, I filed the photograph.
No, but still, that's why we wanted a factual report. The report of the Tahsildar be placed on record with an affidavit. With an advance copy.
Dated 20th August 2022. This report.
Dated 20th August 2022 be placed on record together with an affidavit with an advance copy to counsel the petitioner within 1 week from today. List on in the regular list. List in the regular list on 27 January.
Interim order to continue.
Interim order to continue.
One thing, in 1973, the lease was granted. I'm still continuing over that.
How can you say that, sir, in view of what the report says?
It's within
the AIMS campus. You can't say you're in possession.
That is exactly their counter is that pursuant to their determination of lease,
actually, all this had to go in a civil proceedings. This is the whole problem. Everything is brought in a writ petition.
No, my lord.
Anyway, we are ordering these inquiries. The inquiry is against you. When it is against you, you want to.
No, my lord. Your lordship has specifically put the question that whether I'm in possession or not.
Yes, there is nothing to show that you're in possession.
For that purpose, your lordship has asked me to submit a status report.
All right, 27 January. All right, 28. Sorry. What about 18 January? 18 January.
Item number 8.
None appears dismissed.
Item number 9.
None appears dismissed.
Item number 10.
Same.
Item number 11.
Item number
No instructions dismissed.
Item number 12. Item 12.
None appears dismissed.
Item number 13.
May I please, Your Lordship?
Yes.
Your Lordship, the issue involved is the issue regarding the fairness of domestic inquiry. While deciding the issue, the London Labour Court has declared that it was unfair. So, Lordship has an identical matter has dealt with the matter, Lordship. Deciding the
that he can't stop.
My Lord,
he has to again further adjudicate.
Oblige, Your Lordship. So that opportunity may kindly be given, Your Lordship.
No, but here notice is not gone, sir. Oh, it has gone. All right.
My Lord.
The present petition by the management seeks to challenge an order dated 25th October 2012, passed by the Labour Court Sambalpur in MC number 2 of 2009, whereby the Labour Court held that the domestic inquiry preceding the termination of services of the respondent workman was unfair. Paragraph. The point urged by the management is that the Labour Court could not have stopped with the above finding, but have proceeded to decide the case on merits as well. Paragraph. Indeed, in Karnataka State Road Transport Corporation versus Lakshmi Devamma, AR 2001 SC 2090, the Supreme Court has observed is under this 8 to 8. So, in that view of the matter, the court sets aside the impugn order dated 25th October 2012, passed by the Labour Court Sambalpur, and holds that the prayer of management to be permitted to lead evidence on the preliminary issues of the fairness of domestic inquiry shall stand allowed, and that issue will be decided as a preliminary issue. Full stop. Matter will be listed before the Labour Court for direction. The matter may namely, what's the MC number, is it? This is case number 2 of 2009, will be listed before the Labour Court Sambalpur for directions on 6th March 2023. A copy of the orders be sent to this order be sent to the concerned court immediately. Okay.
Item number 14.
In this matter, my lord, by the elapse of time, my lord, there are so many prayer number. I am placing prayer number B and E, my lord. So far, it regards to the settlement of our rights, my lord, and that extent annexure 27 is pending, my lord. That may be considered by opinion number 9, my lord. Other pairs I am not placing, only placing my lord prayer number B and E for settlement of rights under the Forest Right Act, my lord. And that extent annexure 27 is pending, opinion number 9. That may be considered.
Annexure?
Annexure 27 series.
The counsel, the petitioner limits the grievance, the present petition. Grant of ROR, is it?
Settlement of rights under the Forest Right Act.
As regards the settlement of rights in favor of the
Scheduled
petitioners
tribes and other
under the
traditional forest dwellers.
scheduled tribes and
recognized by
traditional
2006.
tribal forest dwellers bracket recognition of forest rights bracket Act 2006. So for this purpose, he states that the representation made by the petitioners in their grievance petitions bracket Annexure 27 should be considered by the authorities. And after hearing them, an appropriate order should be directed to be passed. Paragraph. In view of the above statement and limited period prayer, a direction is issued to the
OP number 9, man.
Collector cum District Magistrate Jagat Singh Pur, bracket opposite party number 9.
9 along with ballot opposite party number 6, man.
No, that's not even practical, sir. You can't have both the collector and it's the same.
3 persons we have made the grievance, man.
No. They can't sit
He can ask, he can also ask on the react. That may be right. He can ask.
Examine the petitioner's representation, bracket Annexure
27
series, and after giving the petitioners a hearing to pass a reasoned order. Not later than 1st May 2023. Court clarifies it is not expressed in view of the matter. Petition is disposed of.
Deeply.
Item number 15.
This is matter which is covered by your lordship judgment in the case of automobiles. Petitioner challenges Miller's reassessment order, right? Annexure 9.
All right.
And averment Miller's I have taken at paragraph 14 and 15 at page 12 and 13.
The judge
only assessment order, internal page 35, para 2.
That is what I also want to take my lord's attention. My lords may kindly see. Paragraph 2. After due scrutiny of returns filed by the dealer under section 38 of the OVAT Act, no defect is found. Hence, the dealer is self-assessed on the basis of return filed. The periodical returns are placed on record. No communication of acceptance.
Right.
That is the essence of our lordship judgment.
All right. So it is seen from para 2 of the assessment order in the reassessment proceedings that after due scrutiny of the returns filed in the Orissa Value-Added Tax Act 2004, no defect was found, and therefore the dealer was said to be open quotation, self-assessed on the basis of returns filed, unquote. So, however, the admitted fact was that this was not communicated to the petitioner. Paragraph. In view of the judgment of this court in Keshav,
I am giving a copy to us.
It is plain that the impugned order in the reassessment proceedings is unsustainable in law. It is accordingly hereby quashed. All by quashed. The writ petition is allowed in the above terms. What is
Item number 16.
My lord, on behalf of SK Purohit, let it any other day.
No, what's the reason?
My lord, in this case, the essence of the case is that a record of right has been challenged, that is Annexure 2 series. Prayer is made to set aside the record of right under the Consolidation Act. So how the writ is maintained is also.
You can avail the statutory remedies.
Yes.
Permitting the petitioner to avail of statutory remedies in respect to the grievance made in the present petition about the orders passed in the denotification proceedings under the
OCHPFL Act.
The court permits the petitioner to avail of the statutory remedies available to him in accordance with law. Them, sir, to them. The court clarifies it is not expressed in given matter. The petition is disposed.
Item number 17.
May I please the lordship? My lordship may kindly look at the last order date 28th of June 2022, order number 9. Learned counsel for the petitioner handed over a rejoinder affidavit in which inter alia it is pointed out that
one major hindrance in the way of proceeding with the balance construction work is that there are two private plots, number 101 and 104, inside the allotted land, the owners of which are creating hindrance to the petitioner's proposed construction. It is further stated that in paragraph 7 of the rejoinder affidavit that the petitioner has already constructed a total plinth area of 3,40,424 square feet and has taken approval from the AICTE for running of the education institution. Learned counsel for the IDCO states that he needs to take instructions on the above amendments and make submissions. Now, what happened in the matter is, in the year 2017, a lease was granted in my favor by the IDCO.
No, 1 minute. IDCO wanted to take instructions. What happened?
My lord, your lordships, so far your lordships kindly see first the order dated 15/12/21. Then next order is 28/6/2022.
28 June.
First order your lordship passed, that is 15/12/2021. My lord, here it is a matter for
compounding.
Compounding. That is there. That is there under the provision. But my lord, here in this, it may not be prudent to concede the matter, but to assist your lordship. My lord, one thing that the main grievance is revolved around that they have been allotted the plots, and in between, within that, two private plots are there, 101 and 104. So far, the other part of the order in 28/6 that is there. My lord, I have got the instruction, but specifically there is not answer. And so far, but your lordship will find that in the appeal after the cancellation, and they had given in page 51 to the MD, stating particularly about this 101 and 104 plots is within that. So that is why those people are private persons are creating disturbances. That is why I am not being able to proceed further. Well, so far I get the reply to that. That is page 53. Is 53 which annexure? 53.
53 is annexure 13.
Yes. No, annexure, yes, annexure 13. But that order I don't find that aspect has been there. So that is why, my lord, if your lordship may be persuaded to remand the matter to consider and dispose of to the MD, that will be, I think, will solve the problem.
All right.
Your lordship may not record my concession. I am
very
just
post with
your
this
lordship.
court in its order dated 15/12/2020. Mr. P.K. Manthil, and senior counsel appearing for IDCO, informs the court that there is a policy of compounding of violations subject to payment of fine. There is full stop. However, as far as the present case is concerned, whether the request of the petitioner can be considered in accordance with the extant policy of the IDCO. It is stated that if an order is issued by this court for time-bound disposal of the matter by IDCO after a fresh examination, it will be adhered to by IDCO. Paragraph in that view of the matter, the petitioner is permitted. They have to appear before you, or what has to happen? They have to make a representation.
Let them go to the industry secretary, because he is the authority to. Yes, because it may be IDCO land, but it is under the control of industries department. So the secretary industry will take a decision on this.
The IDCO is
because they have violated the liens conditions.
I have not violated. That is the case I want to put before your lordship. What has happened? 2017, they have granted lease. 2007. Now, because of the encroachment of the two private plots, we are able to construct. Now, I have made a reply to the MD of the IDCO in terms of 32 of the lease deed, your lordship. My lordship kindly see Annexure 5 for moment.
No, IDCO has cancelled it, so government will reconsider. So what is the government
for
can
movement, your
reconsider?
lordship? That is clause 32 at page number 40. It's a non-obstinate clause. notwithstanding anything herein before contained, where the lessee has become liable to be evicted or is evicted from the said property under any of the foregoing conditions, the lessor may be in its discretion continue the allotted property in the occupation of the lessee on payment of such fine by lessee as may be decided by the lessor. And in such case, this agreement shall have effect as if there had been no eviction of the lessee. If my
So let them examine it then. ITCO should examine it.
Yes,
Why-
yes.
My respectful suggestion is that the industry secretary is the authority of this because he is the IDCO is under him.
The lesser here is what? The government?
Lesser is IDCO.
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 So we can't ask the government to take over this.
Let you also direct the IDCO because IDCO is the who has
Correct,
cancelled it.
correct.
Industry secretary is the chairman of the
IDCO. Industry secretary is the chairman of
Right. But let him do it. in this
Yes,
capacity.
your lordship may like the chairman of the IDCO.
Right.
Yes, that is also
You
okay.
see, considering the court's attention is drawn to clause 32 of the lease in the present case, which reaches under para 40 paragraph. Accordingly, a direction is issued that the chairman IDCO, who also happens to be the industry secretary, Government of Orissa, will examine the matter and communicate. And after hearing the petitioner, hearing the petitioner on a date to be within the next next month, which date shall be communicated to the petitioner at least 1 week in advance.
In the meanwhile, let the petitioner make a comprehensive grievance, whatever.
Can you also set aside the cancellation because they have cancelled it already. Then reconsider the order of cancellation.
Okay, accordingly, the following directions are issued. The order dated 5th August 2011, issued by IDCO cancelling the lease, is hereby set aside. 2, the chairman IDCO will, after hearing the petitioner on a date to be communicated to it, at least 1 week in advance, and in any event on or before 15th, 23.
Lordship may observe that this court is not.
Yeah, I'll say that. Communicate the fresh decision of IDCO.
One thing also kindly,
including whether the petitioner can pay any fine for compounding the alleged violations within a period of 8 weeks thereafter. No, within a period of 4 weeks thereafter, in any event, not later than 13th March 23. You see, the court clarifies it is not expressed any view on merits.
Yes.
All right. Paragraph. If the petitioner is agreed by the fresh decision of IDCO, it will be open to the petitioner to seek appropriate remedies in accordance with law.
also permit us to make a representation, exhaustive representation.
All right. Right to the beginning, you will say is cancelled, and then second, you say the petitioner will make an exhaustive representation to the IDCO, to the chairman IDCO. On or before 31st January 2023.
Item number 18.
None of this. Dismissed.
Item number 19.
19, no instructions.
No instructions dismissed.
Item number 20.
Item 20 may plead your lordship. Your lordship, the petition land was acquired by the National Highway, your lordship. And for non-compliance of adequate, non-payment of adequate compensation, he has approached the higher authority by annexed to 3, 4, and 5 series, your lordship. All are pending before the authority for adjudication, your lordship.
No, my lord, as per the my lord statutory provision section 3G5, the petitioner, if not satisfied with the compensation awarded by the land acquisition arbiter, he has to approach 3G5 himself. He has to make application. What is the necessity? You have to file application before the arbitrator, the collector, under section 3G5. He will decide the same.
I have already filed, your lordship.
No, before collector have not filed. You have only prayed. The LO may be directed to refer the matter. There is no referring such comfort with the land acquisition officer.
Collector is the arbitrator.
Yes.
He has to approach the arbitrator. It will be decided in.
Decide the same.
Yeah. The grievance of the petitioner regarding inadequacy of the compensation has to be ventilated by filing an application before the collector, who's an arbitrator appointed in terms of Section 3G, bracket 5 of the National Highways Authority of India Act. Full stop. Paragraph permitting the petitioner to avail such a remedy. The court at this stage declines to issue any direction as prayed for. If such application is made before the collector not later than 6 February 2023, it will be considered in accordance with law. An appropriate order is passed thereon by the collector.
Yes, ma'am.
In his capacity as arbitrator, in terms of Section 3, capital G, bracket 5 of the Act, within the stipulated time thereunder, in accordance with law. No further directions are called for. The petition is disposed of.
Item number 21.
May your lordships, I am appearing for your lordships. Your lordship, this matter is pertaining to Industrial Tribunal Award, your lordship.
Yes.
And it has been assigned to Justice Arindam Sinha, according to
All right. List before the roster bench. But this is a 2013 matter. So all
Yes, your
old
lordship,
matters up to 2015 come to this bench.
This was a part-heard matter, your lordship, before the other.
I'm there for the workman.
I see.
There
It is
for the
stated that
opposite.
this particular matter is a part-heard matter
Yes, your
by the bench of Justice Arindam Sinha. List before the said bench on
It was heard by
9th January. All right.
it was heard by Honorable Justice Talpatra also.
Is there an order saying it's part-heard?
No, but the matter was on the verge of conclusion, your lordship, because the lower court record were also called off. It is also part
No,
of
the
this.
last order is by Justice Talapatra.
Yes, your lordship. Then again, it was changed to Justice Arindam Sinha. It was heard a little bit. Again, it
But
was.
there's no order of Justice Sinha on the file.
Yes, I also wanted to put up before your lordships also, but there is no order being flashing.
Then we can't. Then that bench will simply say there's no order and again send it back here. There'll be no end.
But according.
No, but unless there is an order, we can't infer that it was part-heard by that bench. There's no order by that bench at all.
Obliged.
So why don't you proceed on merits now?
Then can it be taken up after lunch, your lordship?
All right.
Would it be some other day? I'll prepare a date chart. Tomorrow.
Day after
Let
tomorrow.
it remain on board. It'll remain on board. All right. It'll remain on board. It's a weekly list.
Oh, obliged. Yes.
Item 22.
It's in item 20, my lords. There was this TRPC before the Honorable Apex Court, wherein series of writ application, including the present one, has been stayed with the Honorable Apex Court, my lords, at the behest of the East Coast Railways. My lords, it's TRPC, my lords, 832 and 854 of 15, V-Day order dated 14th of December, my lords.
Where's the order?
My lords, password, because we just received the instruction just now, my lords.
All right, we'll pass it over. All right.
Grateful, my lords.
Item 23.
23, my lord, your lordship may dispose of the matter by directing the petitioner to pursue the remedies available under the statutory document.
All right. Counsel petition. The petition is disposed of, permitting the petitioner to pursue the statutory remedy available to the petitioner in accordance with law.
Item number 24.
None appears to see.
Item number 25.
None appears to see.
Item 26.
Same order.
Item number 27.
I am for the opposition party. Esco Miller. SC Das.
All right.
I am only challenging Annexure 5, my lord.
Yes.
But the regulation 97 clearly provides that if meter is defective, then after installation of the meter, 3 meter cycling will be taken into consideration. But here the ombudsman has taken 6 months. That is the only cross of the case. Instead of 3 months for revision of the energy bill, my lord, he has taken 6 months. Okay. The present petition has availed the power supply, my lord.
Lord,
From
despite your
2008, my lord, without the installation of meter, my lord. In my lord. Thereafter, the energy bill was revised and taken to recourse of the Rule 47 of the OERC Condition of Supply Code 2004, my lord. Instead of 3 months, they have taken 6 months. Your lordship kindly see page 24.
Yes.
Page 24, my lord. Para D. Although Regulation 97 of the OERC Code Supply Code 2004 provides to revise the disputed bills by putting monthly average consumption of 3 billing cycles of new meter, but in the present case, as the meter relates 20 years, and if the Regulation 97 will apply, then it will be limited to the consumption considering the period of within the winter season only, without taking into consideration the consumption of the season. The average consumption of 780 units is so arrived by the respondent for revision of the bills by taking meter reading from 11/10/2012 to with R101 unit to 3613, my lord, FR 6081 units appears to be more reasonable this forum than the petition demand to strictly follow the Regulation 97, my lord. OERC Supply Code 2004 to extend benefit to average consumption is restricted to the winter. After if it will be taken into consideration for 3 months, it will come on only 627 units, my lord.
Lord, what happened in this case? My lord, a grievance in the grievance forum, my lord, a complaint case was filed in 2011 or 12, raising the paying for a revision of a bill from 2008, my lord, which is grossly barred by time, my lord. And my lord, the meter was installed, my lord, subsequently in the month of November 2012. In the month of November 2012, the meter was installed, and taking the consumption of December, January, February, March, April, May, June, the units, average units are calculated, and the bill has been revised. The area demand of 2,40,000 has been revised to 1,99,000 and odd. If it will be taken into consideration the month of consumption for November, December, and January, a little amount will be reduced. My lord, so far this writ petition copy has not been supplied, my lord, despite your lordship's direction, my lord, the copy of writ petition has not been supplied to me, my lord, also. And my lord,
copy short money next date, Mr. B.K. Naik was conducting the case. Notice says that copy is short on next date, my lord. Interim order passed on 2081. Next date, copy was short.
Please transfer. We serve him another copy, sir.
Yes, ma'am.
Counsel petitioner undertakes to serve a copy of the petition on counsel for NESCO, is it?
Yes, my lord. Now TPNODL, my lord.
TPLODL. Have you substituted?
No, he has not substituted TPNODL.
An application has to be made by the further. An application will have to be filed by the petitioner for substituting the respondent with the present entity, that is TPNODL. List in the regular bench, not the weekly list. Right. Before the roster bench. On February 9th.
Obligation. Interim order to country.
Interim order to country.
Item number 28.
Item 28, we have given a synopsis and a list of dates. These are all covered by similar orders of this court, wherein the court has allowed the writ petitions. I have given a copy, and if my lord would see, several earlier rounds were there. So unnecessarily, the petitioners have been harassed.
It will be on board. I will examine this covered matter tomorrow or day after tomorrow.
All right, stay on board. All right.
So this may be tagged along with item 42, which is also the same.
All right. Same with item 42. All right.
So it will be
item 29.
Interim order to continue.
Interim order to continue. No, but we're not passing order. It will just be there.
My lord.
Item 29.
None appears dismissed.
Item number 30.
Item 30, my lord. It is So a cover of a division bench. Now the petition already died, so I have filed a substitution petition along with the consolidated cost title, which may kindly be allowed prior to hearing, my lord. And I am now filing the date that it was prepared earlier in the year 2014 in legal size, for which I am sorry, my lord. Where in the action of
No, who has died? Where is the substitute?
Petitioner, my lord.
No, already substituted or not yet?
No, not yet.
Where is the application?
Application is there, my lord.
Which one?
Flag B.
Any objection?
No.
All right.
Substitution
The
can
reason
be allowed.
stated the IA 11630 of 2022 for the reason stated therein, the application is allowed. And the persons mentioned. Yeah. In para 1. So the present applicants
and consolidated
shall be substituted in place of the petitioner. The consolidated cost title be filed within a week. All right. It's taken on record. All right. It's taken on record. Yes. Now let's go to the list of dates.
Next week or today, Mel.
Now you've given it, sir.
Already.
You're the respondent, right?
I'm the respondent.
Now, my lord, the petitioner, being a bona fide purchaser, my lord, he has to challenge the order passed by the settlement authority under annexure, appellate authority also. Now, without having the jurisdiction, my lord, there are a number of judgments. They have passed the cycle style order in including all the recorded land in the government khata, which is exercising the jurisdiction beyond their jurisdiction, my lord, under OGLS Act. They have cancelled under annexure 6, the appellate authority order is there, where self-same findings, page 22, your lordship can see, I have given the date that prior to that, annexure 20. Annexure 20, my lord, under section 12, the not final ROR, that is the draft ROR was issued in favor of the petitioner. So thereafter, the settlement authority has only duty to fix the rent, my lord, unless until it is challenged, that this draft ROR is challenged under section 12A. So now, without doing so, my lord, so moto, the ASO directed to include all the lands arising out of lease, my lord, in the government khata, for which the petitioner also prepared. Now, the appellate authority said so, the self-same findings that Honorable High Court directed in OJC number so which your lordship already held in a number of cases, that direction is limited to make inquiry by a officer not less than the rank of a secretary. And if found any fraud and irregularity, so make the proceed the matter. But without doing so, how the ASO, without having any jurisdiction, exercise the power, that is why my lord.
Your lordship will see the improved order at page 23. There is a clear approach the Tahsildar for, since you are saying that the ASO has no jurisdiction, the second paragraph, the appellant is advised to the Tahsildar Bhubaneswar for redressal of his claims, or may approach any other forum. So the liberty is given to you to approach the Tahsildar.
Well, your lordship can see in this regard, your lordship
if you say that settlement authority has no jurisdiction, then the Tahsildar will take care of it. You approach him. That is the finding.
Because my lord, the Tahsildar jurisdiction is seized at the time of during the period of settlement operation. After publication of ROR, unless this order is set aside, so Tahsildar cannot exercise his power, my lord. That is why your lordship can see that revision bench order, there are two number of judgment. And
My respectful submission.
after going through the impugned order, it appears that Assistant Settlement Officer, Rental Colony, Bhubaneswar, paragraph 4, I am reading. Case number so and so, reviewed the order dated ethically passed by the additional district magistrate Bhubaneswar in revision case number. So here, my lord, leads OGLS Act, under OGLS Act, there is a power delegated to the Tahsildar under section 3B for resumption. And under section 7A, the ADM is delegated the power. Now, when they have exercised all this power, how the settlement authorities, that is why your lordship can say that categorically held the Assistant Settlement Officer has no jurisdiction to review the order passed by the revision authority in proceeding of OGLS Act. Number two, my lord, second judgment, your lordship can see. Large number of case already disposed wherein following all the Honorable Apex Court judgment and all judgment, it was heard at length, and thereafter the number of cases was disposed with a direction that the Assistant Settlement Officer has no jurisdiction to exercise except the OSS Act, and thereafter it was the impugned order was quashed and remitted matter to with a correct the final RR within 3 months.
My respectful submission is that your lordship may directly Tahsildar that pursuant to this order, impugned order, he will accept the grievance of the petitioner and pass necessary order independently.
Your lordship can set aside this order?
Yeah, naturally.
That's
why the fresh order, this order goes.
My lord, may just
set aside this order?
Because I have other two matters, 75, 76. In 75, I will be seeking time for petitioner's diet. So for the 76 is concerned, because it is like the same matter. My lord, the crux of the matter is that in course of settlement operation, the settlement authority cannot act as the authority under the OGLS. Your lordship will find in that impugned order, he has dealt with everything that is Westland lease case, and land has been presumed to have been given illegally, all these things. These are all extraneous, innocuous findings.
That we will
he has
consider
no authority.
in that case.
And will not Tahsildar has no power. So far the matter between the settlement process is there. So that is, my lord, it may not be correct as my learned friend Mr. Mahathi says. The settlement authority has no power. Only, Tahsildar has no power. Only this matter has to be, this has to be quashed in view of the division judgment is already there.
Just one.
My lord,
after 34, my senior advocate also submitted absolutely correct. After publication of a final order, under Rule 34, if your lordship quash the impugned order, so Tahsildar has power to interfere under section under Rule 34 of OSS.
That is the observation. The appellant is advised to move the Tahsildar Bhubaneswar for redressal of his claims.
So
they approach
now they are giving the findings different wrong findings. It will go stand on the way.
Then your lordship may say that without being influenced by this.
He has directed to record the land in Avat Joganavati in the government kata. How the Tahsildar will interpret in the matter?
No, Tahsildar has, you say that his settlement has no jurisdiction. Tahsildar has no jurisdiction. That cannot. What Mr. Samantra is saying, that Tahsildar has the jurisdiction under Rule 34 to correct the record of right or to initiate resumption proceeding, or 7A ADM is the empower. But that is why my responsible submission is, without going into all these controversies, the impugned order itself says that the Tahsildar has been given liberty to look after the claim of the petitioner, the observations of the settlement authority. He will do it.
Tahsildar OSS Act, there is no jurisdiction of the Tahsildar unless the final RR is published. So since the final RR already published, my lord, 12B, under section 12B, so only Rule 34 provides to the Tahsildar to exercise the power if any impugned order is set aside by the higher authority. So unless your lordship set aside or pass this impugned order, Rule 34 cannot be exercised.
Oh, that's not an issue.
That is not an issue at all.
That is the issue. That is a statutory issue.
What is this? Your lordship, it is dealt by another division bench judge. All they have acted on this piece. My lord, thousands of cases were disposed of in one day.
Which is your matter, sir?
89, man. I am 89, 90, and another.
I have also got the division.
Number of cases listed today, my lord.
Yeah.
This is jurisdiction, your lordship can see that the division.
That is
That division.
Mr. Samantrai, this is the observation. If your lordship will quash it, then there is nothing. If your lordship will say that notwithstanding the observation of the settlement,
he has to pass a fresh order, the earlier order has to go.
And that is what. He will
let the impugned order may be set aside, and thereafter under Rule 34, Tahsildar may kindly directed to exercise the power. So
no, you have to make the claim. That is the observation before the Tahsildar. Tahsildar will adjudicate. You have to file a case that this record of right may be.
Your lordship can Rule 34. Your lordship can see, my learned friend. I think
Rule 34 is very common rule. That is always we are dealing with
grounds on which correction of a record of rights and map is to be made, my lord. The Tahsildar may an application on the behalf of that person interested on or receipt of the report from any his subordinate officer on receipt of a notice from the register, sub-register appointed under the Indian Registration Act or from court on his own motion or one motion, there is also one motion. Any charge of entry according to the rules hereinafter prescribed on any one of more than following grounds. The grounds which are the grounds, my lord, that all persons interested in any entry in the record of rights wish to have it changed. That the decree of the civil court, that being founded by the decree of the civil court is so and so. So final ROR, if it is final ROR already published under section 12A, my lord, so Tahsildar only 34, or if there is no obstruction, so the impugned order, if it will stand, Tahsildar cannot exercise his power against the order passed by the SO.
In my case, it has been directed to be recorded in the name of the government. Abad Jogan.
Everywhere.
In every
Let me say these are the cases where vigilance inquiry is going on in Bhubaneswar town, 1950-51, that some leases
No, that is already over. Since long.
All these, they have transferred the land to third parties.
No, but that inquiry can't be going on and on, sir.
No, that is, I'm not placing that. I am saying these are all tainted.
What is the outcome of that inquiry?
These leases are all tainted with fraud. That is the finding of the court.
No, you cannot say this thing. That is, nothing is there on record.
So that is why all these leases are cancelled.
What happened to that inquiry? It's not concluded.
Inquiry is
can't be open
pursuant to the order of the Honorable Court.
That is over
some years ago.
Yes.
Well, that is over in 19. Pursuant to the direction given in the PIL. And that is already over. But then already the Revenue Secretary woke up and directed start the settlement operation. All leases which have been given, even if invalidly, so that is gone. Even if validly, take all land to the government record. That is the direction, observation by.
I may be permitted to your lordship for us prior to passing that judgment, that order in the case of a Kapleswar Farm Private Limited, both the ASO and SO were present in person, and they were asked to put up the question, how does this order? Specifically, they have ensured there is no instruction guideline, only verbal instruction of a Secretary Revenue. Then,
per day, 1,000 cases will be solved. Not giving the information to the.
So you have to speak in the mics.
Mic.
My lord, I have some cases, my lord, 89, 90, 104 to 108, my lord. These are all same and similar order in everything. In another case, division bench of Honorable I. Mahanti Diden
And
Sir, you'll have to show us copies of orders.
my
You
lord,
can't just.
They are given.
That
order
that-
passed on 4/7/2014. Order in WC 8237 of 2014.
My lord, my
Mr. Kalyan Patnaik,
yes, ma'am. 840,
you know,
your lordship.
you are required to produce the order on which you are relying on and you are presenting.
8402, ma'am.
Pass on that.
And
Yes.
let us go one by one. Now the matter is of Mr. Samantra. Let that be disposed of, then we will go to the next.
Your lordship, see, all same, my lord.
No, all are not.
All are same.
All are same. Same order passed with the
Ultimately, secretary will come to the file affidavit himself. Your lordship. Yes, ma'am.
Yes.
All these Your lordship, see, judgment is a stereotype cycle style order, except the khatar number and plot number.
My lord, there is another astonishing also, your lordship can be surprised. It is not only directed to record the land in favor of government, it was already recorded in Kisam Jungle. In Kisam Jungle.
That was the Sabik Kisam. That is the old record.
They have
That is the old record. So,
Bhubaneswar town, it is recorded as jungle.
Jungle.
That lordship has recently dealt with one case where this quarter of legislature, that is also jungle Kisam, your lordship has directed to pay compensation. In Bhubaneswar town, lot of properties are jungle Kisam. Not that everybody knows, and Mr. Samantra knows it better than any of us.
My lord, secretariat is standing in the
Kisam jungle.
In Rampur jungle. 1927, it is declared under 1927 Indian Forest Act.
Unnecessary.
My lord, there are two forest division declared under the Indian Forest Act 1927 and Rampur Reserve Forest.
My lord, so far as this present case is concerned,
that
if
is
your
in
lordship will see, the
not been
petitioner's claim is that I have not been heard. It was dismissed without hearing me. That is, principle of natural justice has not been followed. I am just submitting in the case of Mr. Samantra. If that is so, your lordship may remand the matter for hearing. He will raise all these questions. And neither he will go to Tahsildar nor he will go to the settlement officer on remand. He will say that this court should pass an order that the record should be corrected. I strongly oppose it.
The indulgence of your lordship, I am in item number 111. My issue is substantially similar to the issues canvassed by the learned senior.
That's what I think is smart. Stage. We take up case one by one.
Yes, your lordship.
Small difference.
Cannot be.
What we'll do, we'll resume after lunch. We'll start with Mr. Samantra.
Okay.
Yours is 2780. Yours is 2798.
Item 30.
Item 30, madam.
2798.
2798.
Right.
Well, the date chart is there, my lord.
Right.
Given, just I have supplied my written note of submission.
I see. Correct.
It was prepared earlier, my lord, 2015 in legal side.
Right.
The land measuring 107 decimal in plot number so and so in the year 1959 and 60, the lease was granted in WL lease case number 619 of 1959 and 60. After death of Panu Nayak, his only son Brajabandhu Nayak, being inherited, continued his physical possession over the expiry of more than 30 years due to requirement of a heat transport. Now, the annexure 1, your lordship can see that is the ROR was corrected in favor of the
Brajabandhu Nayak.
annexure 1 is the sell deed. His son was sold it after expiry of 30 years from the date of allotment. Thereafter, when the bona fide purchaser was in possession, both were the scheduled caste category. So, 2, he also obtained the necessary permission from sub-collector, my lord, under OLR Act, under section 22(1)(b)(4), and thereafter he transferred in the year 1992 under Annexure 3 to the petitioner, my lord. The petitioner mutated the scheduled land measuring under Annexure 3. He also mutated and corrected the ROR in his favor. Annexure 3, my lord. The petitioner corrected the land and recorded in his favor at the time of effecting the mutation, my lord. That is Annexure 7 in Odia. And during the period of a settlement operation, he has also paid the rent revenue up to 2013. During the period of settlement operation, my lord, during the period of Khanapuri, the Yadasta and both the Pacha, that is the not final ROR, that is the draft ROR were issued under Annexure 5 in favor of the petitioner under Annexure 5, page 20, my lord. And it was issued under section 12. So, without challenging the same, the ASO corrected direction, entire government land, the leasehold land was recorded in favor of Abad Joganabadi, directed to be recorded. Thereafter, he preferred an appeal, my lord, under Annexure 6, page 22. Where Khata number so-and-so, plot number so-and-so, bearing a leasehold land, recorded in Khata number so-and-so and recorded in the name of Sri Subhash Chandra Samantray in Dakhal Satya Sudna status, the lease principle are follows or not or cannot be confirmed due to non-availability of documentary proof. So during period of mutation, the Tahsildar also followed everything and mutated in favor of the petitioner. Now it is only the presumption as per the instruction of given by the government. And this order was passed, which order was challenged before the lordship. Only this order was passed in being referring to the judgment, the lordship last whether the lead in OJS number 9449 of 1993 dated 29/1/1996 is to know this office. The appellate also cannot submit the lease deity including the test map of the leased out land. So first they have inquired the matter, field inquiry, everything, and issued the final, not final. Now this order was verbally was passed, being vested in that Honorable High Court's judgment to refer. So in which judgment your lordship categorically held in number of judgment orders that here the Honorable High Court directed to make inquiry through a senior officer just not rank not less the rank of a secretary. Now without making any inquiry, nothing else. Now the during period of possibly they have in the government khata.
No, but your appeal was dismissed because of non-prosecution, is it?
The appellate is advised to Tahsildar advise the Tahsildar Bhubaneswar for redressal of his claim may approach either for my lord, he is the settlement authority, settlement officer. Settlement officer is equal rank to the sub-collector, my lord. how, unless until this order
Against the assistant settlement officer's order.
My lord,
Come to your page 2 of your list of dates. Sir, are you able to hear me?
Yes.
You're able to hear me?
Yes, yes.
Come to page 2 of your list of dates.
Page 2. Yes.
Kindly read the last date in that.
Yes.
5th October 2013. What happened to the appeal
When
filed
the
by
petitioner failed to get any information about such inaction of assistant settlement officer, he preferred an appeal bearing 2172 of 2013 before the additional sub-collector come additional settlement officer who was delegated at that time to exercise the power of a settlement officer. But the appellate authority dropped the appeal.
What is meaning dropped meaning? He disposed of, he dismissed, he allowed. What is dropped?
Dropped means he has not heard or passed any order against since the land was.
No, the appeal is pending.
Yes.
No, the appeal is pending or it has been disposed of?
Disposed of.
What is dropped meaning what?
Dropped means they have used that language.
No, can any appeal be dropped? Or it has to be adjudicated or decided?
My lord, rightly or wrongly, that word has been used by the
applicant.
What does it in effect mean? It is
in effect, it means that the appeal is disposed of.
So it dropped means dismissed.
Dismissed.
I've never heard of this word. That's why
during the settlement operations, before the final publication is made, there's a provision for appeal. After the final publication is made, there is no provision for appeal. One goes in revision under 15B of the Act. So if the final publication takes place, the appeal becomes infructuous. So it is dropped.
So here final publication has taken place.
I do not know. I do not know the fact.
That is what I want.
So when here you are not given date.
Final publication, perhaps they are giving the back date, my lord, 2000.
Don't say perhaps and all, sir. We are deciding a matter. We can't say perhaps.
Mauja, on the road.
No.
On the
final publication.
So 2013. December 2013.
Somebody is giving you date. You are simply saying it. Either you say I don't know. Are you aware or you are not aware?
I have heard about not knowing any reference with my.
Why? This is your case, sir. If you do not collect facts, who will collect it? Because if there is a final publication, Mr. Mukherjee says you can only file a revision.
That's why it is wrong. So you are not aware that you are revision. So now you cannot
challenge it in the writ petition.
If he wants to regularize this.
That's the thing. Yeah. Once there is a final publication, there's no question of sending it back to Tahsildar and all.
May I just add one more aspect? This finding rendered in one of the petitions, which I had argued for this honorable court, that the final publication, because it was found by this honorable court that even after the final publications, the officer concerned was dealing with records and passing orders in certain cases. So, in fact, the entire final publication dates which they have given are have been created for the purpose of showing that final publication has taken place. In fact, final publication has not taken place.
How do we know all this, sir?
But it is to be guesswork. Case by case.
Finding rendered in a petition.
In this particular case, was there a final or not? We need to know that.
That is the most important.
They have given a date that final publication has taken place in respect of so and so Moses.
In this case, they don't seem to have. In this case, the case we are now dealing with, 27898, there's no indication when the final publication took place.
In fact, if I may add, the earlier batch with Mr. Mukherjee and I was also there. Earlier batch, an affidavit was produced saying that a secretary rank officer has directed all these ASOs to reject these matters for Bhubaneswar. Those affidavits are a part of some rate petition.
In fact, that's how the 2014 orders were extracted from the affidavit.
Correct.
They've done all that.
So here, in cases, now there are some cases where the matter has already traveled to this court and this court has confirmed, and thereafter again they have cancelled it. So in fact, my case which has been passed over.
No. In these cases, the court went on the presumption that the settlement operation has not concluded.
No, in some
all
cases,
these, whatever we've been shown so far,
my lords,
we've been shown 2 orders of 4th July, 8th July. All these proceed on the basis that the settlement of
order, my lords, 2014 order, a division bench order, I think rendered Mahanti and Gill, that says that even if the final publication has taken place, it would be deemed to be set aside and then go re-adjudicated.
Yes.
The concluding part, your lordship may see.
No, in fact, I'm reading the order of the bench of Justice I. Mahanti and S.K. Sahu.
Yes, my lords.
We find from the affidavit of the Additional Chief Secretary that settlement operation respect to the Mozas concerned has been continuing since 1995. The court expresses concern that despite the fact of lapse of 19 years, the settlement operation could not be completed direct.
No, thereafter, the observation is that even if, because they made a submission before the court that they have concluded in the meantime.
In this, there is no such observation.
We further make it clear that the assistant settlement officer shall conclude the proceeding.
Correct.
Sampur Mauza.
Yeah.
Sampur.
Correct.
Sampur na ko Mauza.
Sampur ta hai.
One day.
Oh Mauza.
Here in the orders shown to us, it will not conclude.
My lord, all these cases relate to 2 Mauza, Andharwa and Sampur, perhaps. And I will take instruction what is the status, whether it is final publication has already been made or not. Because
Sampur, there is no final publication as yet. Huh?
So when somebody used the word dropped, it must be that because that's a final publication. That's why he's dropped it.
No, there is no indication in the order that since the final publication has already been made, I am not going to exercise my appellate power.
So may I suggest, my lords, let the state find out in which areas it has been final publication has been made. In the meanwhile, we from the petition also get those orders where these orders have been passed after final publication.
All right. You just give this all
If
back.
they want to file counter, because in none of the cases they have yet filed counter.
I know it's a 2014 matter. Now they'll have to get on with it now.
So the
How long will you take to find out?
2 weeks, within 2 or 3 weeks.
All right.
Because these are all related to Andharwa Mauza, I think. If other Mauzas are there, kindly give the details of the Mauzas where the suit land is situated. So that individually I can. No, that is okay. In that case, I have to find out all the writ petitions and get the details of the suit land, then I can get the instructions.
In some cases, the matter has ended already in the High Court. Still then they have reviewed it. They are as if they are sitting in appeal over the orders of the High Court. My case, in fact, I have given that entire order, everything is there.
Just put down all these 32 to 34 and which are the other matters now?
So 34, up to 34.
So far as my matter, it's 28 and 42, where matters have ended already in the High Court. So now the impugned order just overreaches the orders of this honorable court.
No, but in your case, is the settlement operation complete or not?
No, so far as when it was challenged, it was not complete. In 2014, it was not complete.
My lord, in the event we will be filing the revision, which is challenged before a lordship, that is without jurisdiction. Because the settlement officer has assumed the jurisdiction of the government land. That is the crux of the matter.
That is there. That can be observed.
So that
but if you invoke the revisional power, then the revisional authority will consider the case.
He will not be influenced by this order. This finding will not stand in the way of deciding the matter on merit. That will be different things. But how can the assistant settlement officer will assume the jurisdiction of the government settlement authority authority, which is section 3 or 7 for cancellation or revision of the settlement already made under the OGLS Act. But he is an authority under the settlement, Orissa Servant Settlement Act. So that is why in the division bench, it was held that they have no jurisdiction. That is why the order has been settled.
No, but how does the situation change if there's a final publication?
If the final publication is made, the only remedy for them to approach the commissioner under section 15B of the Act.
That is in a routine manner. But so far the jurisdiction of the authority in passing the order.
And in that eventually, your lordship can observe that this order will not stand on the way or to decide the revision on merit.
So the revision will be filed against the final list.
Yes, my lord.
Final publication.
Against the final publication.
My lord, in fact, these are all matters of the single judge. Because we have mentioned under the Survey Settlement Act. Why you have mentioned under the Government Settlement Act, Government Land Settlement Act? Because the Assistant Settlement Officer has decided something. My lord, adheres the power and usurpation of power of the Government Land Settlement Authority power. So that is why otherwise this is an order under the Odisha Survey and Settlement Act. It would have gone to the single judge. But how will your lordship decide the matter so that both the forums we can get here? The lordship can decide. That is why we have given the division bench judgment. And even my lord, one of the order of the Honorable Justice B.K. Naik that I was doing, there it has been also directed this order goes. Yes. And he has to decide the matter afresh, taking into consideration whatever the record of right, how it has flown, all these things, without entering into the matter to the Odisha Government Land Settlement Act. And in the meanwhile, if any record of right has been published, that is also quashed. That order I have not passed on. That is.
If my learned friends will agree with me, your lordship may say that wherever any final publication is made, the court is at liberty to approach the revisional authority, and the revisional authority will decide the case under section 15B without being influenced by any order passed prior to it.
And the status quo will continue.
Status quo will continue. Status quo.
What about the other cases where no final publication has been made?
That is perhaps no case is there such type.
May I please seek the attention of your lordship? I'm sorry I'm interrupting out of context, out of turn, but your lordship's query, my case fits into your lordship's query. In my case, there is a preliminary draft notification. That notification has been necessitated because my original final ROR has been disturbed on account of an illegal order passed by the additional district magistrate, which was set aside by this honorable court in the year 2006. So because that order came into picture and subsisted for 5-6 years, my original ROR, which had attained finality, was disturbed. Pursuant to your lordship's order in 2016, a preliminary notification was again issued under section 12. The assistant settlement officer makes a proceeding that there was in fact a finally mutated ROR in the year 1991, only because of this order passed under 7A and the quashing of that order by this honorable court. The ROR which has been disturbed needs to be restored, and there is a clear-cut observation that the land has to be now recorded in the name of the petitioner. And pursuant to that, a preliminary notification is issued under section 12. There is no provision in the act at the stage of section 12 to enter into a suo moto proceeding where the observation of the assistant settlement officer itself is resiled, and as ASO has in a way taken a diametrically opposite position order and has passed this suo moto order in the lines of the orders that the learned seniors have been emphasizing about. So in my case, I won't be amenable to the revisionary jurisdiction under section 15B, in as much as my order is an order under section 12. Section 15B gets attracted only when there is a final ROR. In my case, there is no final ROR. The findings of the ASO is based on extraneous considerations which are foreign to my case.
So did you file an appeal against the order of the ASO?
No, your lordship, there is no appeal which is maintainable. An appeal is envisaged under section 12A, your lordship. Section 12A gives me a right to an appeal in a limited circumstances where my passed under section 12 at the preliminary stage can be assailed. So I have no grievance in respect of orders passed under section 12A because the preliminary notification was in fact in my favor. So therefore, I had no occasion to invoke the appellate jurisdiction at that stage. It is only because that the ASO...
12A says...
Item number is?
From every order passed by the ASO. No, under section 12. Her favor. Watch out.
Your Lordship, section 12 speaks about preliminary publication of draft record of rights.
That was in your favor.
Yes, that was in my favor. Section 12A gives me the opportunity of appeal. Since that preliminary record of right was in my favor,
you couldn't have
I
filed
had
an
no
appeal.
occasion to file an appeal.
Right.
This digression from the preliminary notification, Your Lordship, is outside the contours of the statute. The only stage at which the authorities have
tell me one thing. This ROR, draft ROR in your favor couldn't have been under the Survey and Settlement Act. How can it be under that?
The OGLS Act, I have a lease. This honorable court has upheld my lease in 2016 and has held that that lease is in order. Because of this, as a consequence of this order of this honorable court, the ASO has himself passed an order saying that we have to comply with the order of the Honorable High Court and therefore the names have to be mutated, which resulted in this preliminary notification. I had no occasion to file an appeal and the stage of revision has not arisen because the ROR in question has not been finally published. 15B gets attracted only when a finally published ROR comes into picture. So I have no alternative remedy but to approve. And the learned ASO has acted outside the contours of the Act, Your Lordship.
In this case, I think a counter has been filed on behalf of the settlement.
No, there is no counter which has been filed.
This is Sandeep Dhawan. Sandeep Dhawan is the petitioner.
Serial
Petitioner is Safiq Khan, serial number 111, Your Lordship.
111.
Safiq Khan.
Oh, sorry.
Safiq Khan, correct.
Yes, Your Lordship.
Which model?
So this is an order starting a suo motu case. What you've challenged at Annexure 7.
Yes, Your Lordship.
This is a translation, obviously.
No, this is at Your Lordship is looking at item number 111.
That's right.
Your Lordship, at page number 31 is the order.
That's right.
Yes. So this
This is a translation, I think.
no, Your Lordship, it is the original order. It's a handwritten order.
I see. So just come to the last line. Hence, the court thought it proper not to record the government land in favor of private individual, right?
Yes. Your Lordship.
The affected parties have scope to appeal before the appellate authority.
There is no scope of appeal. This direction is misconceived, Your Lordship. Appeal I can only file against any proceeding which has taken place under section 12. Now, which speaks of the preliminary notification, Your Lordship. Section
No. What is the last sentence? Hence,
suo motu case is allowed.
Allowed.
Allowed. And order in vernacular. It's
because the government was the initiator. Suo motu case has been initiated by the state
government, Your Lordship. Because the lands, if Your Lordship sees the first page of that order, it's mentioned in vernacular.
So it will be an order in section 12 now. Once he says the suo motu case is allowed, it becomes an order under section 12.
Your Lordship, allow me to persuade you otherwise. May I please invite your...
Yes.
Your Lordship, section 12, preliminary publication of draft record of rights. When a draft record of right has been prepared, the assistant settlement officer shall publish the same in the prescribed manner and for the prescribed period, and shall receive and consider objections which may be made to any entry therein or any omission therefrom during the period of publication.
Correct.
In my case, objection.
No, this objection is from the government.
From the government side itself.
That's the whole problem. This is the objection by the government. And government, it's not excluded. The possibility of government objecting is not excluded. And therefore, he says, I'm allowing the objection of the government.
It reads suo motu. So
that's right. So the government itself says now there are directions saying all these are fraudulent transactions. And therefore, I'm exercising that suo motu power. And I'm therefore raising the objection to this draft entry. And he's therefore said it. See, even in the earlier sentences, he's come to the conclusion this is government land. He says, since it is government land, it cannot be mutated in favor of private individuals.
The question is whether he can do that.
No. That is
after the ADM.
No. We are on the limited thing. Can this be construed to be an order under section 12?
Yes.
No, it cannot be, because what has happened is a draft ROR has already been published.
Correct.
That is under section 12.
No. It has to reach a logical end. That draft has to reach a logical end.
No, the objection which is now coming in.
No, there is no publication.
There is a publication.
Only draft.
The draft record of rights.
So that draft, there will be objections to the draft leading to a final order under 12.
That's it. No, final. If draft publication is finally made under section 12 and it is published, and those RORs are also circulated among the parties, which I believe many of you would have annexed to the writ petition.
Your Lordship, at
after
page
that, then objections are invited.
So look at the word of 12.
The opening word is the
order
draft record.
Shall
right.
appeal shall lie from every order passed by the ASO under
section 12. But section 12 order is in favor of the person concerned because the draft was prepared in his name.
No. The publishing of a draft record of rights is not an order.
It's a publication made.
So the word used in 12 is against an order passed by the ASO under 12.
After the order is made, a draft publication is made. The draft publication is also a record of right. It's known as the not final ROR.
It's called Parcha, Your Lordship. It's at page number 29 of my petition. It records my right, but I appreciate what's falling from Your Lordship. I perceive that Your Lordship means that there is in fact an objection by the government, and it is the objection of the government which has been decided.
Yes.
To that, Your Lordship, allow me to make two submissions.
Yes.
Firstly, if Your Lordship looks at the survey and settlement rules of 1962,
right.
Rule number 27 deals with these kind of objection.
Right.
It also envisages that these objections will be served on me. These objections have to be filed in a particular form, Your Lordship.
Right now, we are not on the correctness of that order passed by him. We are on understanding whether it is an order within the meaning of 12 capital A.
If there is any irregularity, that can be cured in appellate jurisdiction.
Not during. I mean, during meaning the draft will say within 30 days. And you have to make an objection within 30 days. Then an order will be passed. Yeah. Just look at hypothetical situation. You have a draft publication inviting objections. There are objections. Let's say there are objections by private individuals. Hold the objection by the private individual. So he will pass an order saying, I find force in this objection, and therefore I decline to grant this mutation. So, right? So that will be an order under 12.
No.
But Your
That
Lordship,
will be an order under 13. That will be the final publication.
Then what is the order under 12 that is 12A?
12 is basically an authorities have to do on the basis of the records which are available in their office.
No. What is this order?
They will say that so-and-so land stands recorded in the previous record of rights in the name of X. In the meantime, X is dead. He has been survived by so-and-so. So it will come in the names of so-and-so. Otherwise, he will go look into the encumbrance certificate, find out if there is an alienation of the property. And if the alienation is there, he will record the name of the purchaser. And that is how a section 12 application will be made.
In which case, this order in this case will be an order under 13. If it is not an order under 12, 13, then from what you say.
Yes, and that will be followed by a final publication.
But 13, it will be an order under 13. Then 13, the next stop is 15B.
Then, my lords, the final publication will have to be made.
No, that's right. So, final publication will therefore show the land in the name of the government.
Final publication will show the name in the name of the government, which is being asserted before your lordships.
That's right. No. For which the route is 15B. That's what he was saying.
Yes, well, the 15B.
The route is
the final publication is made.
There is a final publication, which means if there's an order passed pursuant to an objection under 12.
No, what has probably happened here is that a particular objection is taken into account, orders have been passed. Now, this will have to happen with respect of each one of the plots before a publication is made. And only after the entire exercise is completed, then in respect of the moja, it is not in respect of one plot that a publication is made. It will be made, publication will be made in respect of the entire moja. So once the entire exercise is completed, only then a final publication is made, and final publication then right under section 15B will accrue. But my lords, if your lordships examine these case records, these are all exercises without jurisdiction.
Look at 13. It does not say that till the entire plot for all, the entire moza is decided.
Record of right prepared and finally published.
Any record of right prepared and finally published.
Finally published in respect of moja, that is there in the rules. It cannot be for a particular plot. Rules, I'll show the relevant rule.
So in any case, what my learned friend is submitting, if it is an order under section 12, then it is applicable under section 12A. If it is an order under section 13, then we have to wait for the final publication. It was not under section 15B.
Kindly see rule 29, Manoj. The copy of the map and record of rights, not one, rights, finally published. Frame shall be finally published by the assistant settlement officer by placing them for public inspection, free of charge for a continuous period of 7 days, at such convenient place as will be determined. Thereafter, not less than 7 days from final publication, in accordance with sub-rule 1, the assistant settlement officer will issue a notice in form 6 to be published in manner specified in rule 6. On the expiry of the 7 days, in sub-rule 1, proceedings, certifying the final publication of record of rights. The copy of the map and every page of the record of rights, which are finally published under sub-rule 1.
Can we do one thing? See, in cases where a final publication has taken place, we'll relegate parties to the revisional authority.
Yes.
In case where it has not been published, we'll direct them to now publish it, reserving the right of all these people who may be aggrieved by such final publication to go for a revision. So either way, the status quo is not disturbed, and either way, they have a remedy. Because ultimately, it has to end only there.
No matter, the difficulty is this, Manoj. Manoj, just one.
Published, it stands fast. Lordship, kindly see that order.
Final publication.
Final published. Because Lordship held that the settlement authority has no power to enter into the arena of Westland lease case, which is passed under the Government Land Settlement Act, because their authorities are different authorities. It is only at the instance of the Revenue Secretary then, as it was recorded by my Lord Justice Mahanti, at that his instance only, my Lord, in all cases, in a stereo manner, in copy pasting order, that has been passed.
No, then for one set of people where all those orders which are shown to us, they will have to go for a revision.
Revision.
Those orders, since the final settlement operation was not over, they were all sent back to the ASO. And for after the orders of the ASO to go for revision, obviously.
There are some cases where lands were settled by the ADM pursuant to the orders of the court. The question which came before this court was whether the ASO can overturn the orders of the ADM. There are a series of orders which have probably been shown to your lordship, where they say that the order of the ASO is without jurisdiction.
Right.
So those cases, if we are sent back again to the revisional authority, then it will just multiply the problems of these individuals.
The revisional authority will examine if the ASO is acting without jurisdiction.
No, what has happened is this, why it is being said that it's without jurisdiction? Because this honorable court, but this is the second round, most of these petitioners are fighting.
Third round.
The first round was all the diseases were cancelled under FNA 3 of the OGLS Act.
Correct.
Now, 90% of these cases decisions were overturned by this honorable court, and the honorable court held that the diseases granted were proper. So this was the end of the first round of litigation. Either this honorable court held or on remand the ADM held.
Correct.
Thereafter, the settlement proceedings started. There, on the orders of one superior officer, the entire Muja, these are lands on the periphery of Bhubaneswar city. On the orders of one officer, the entire lands were recorded in the government khata, taking away from the private individuals who had 10 transfers in the meantime, constructed their house and they were living there. So, this is the second round for which the court held that the settlement authority had no authority to sit over the order of this honorable court and the ADM. They were superior officers and they had statutory powers under the OGLS Act to adjudicate about the right titles, which a settlement officer does not have. The settlement officer does not have the authority to decide on the right title interest of a person. He just has to, his limited brief is to see from whom the revenue is to be collected. For that, he cannot title of the person concerned, which has already been decided in a properly constituted proceeding.
So can we not say that in a revisional petition under 15B, that revisional authority will consider whether the ASO had jurisdiction or not?
It's becoming so very onerous for these people who have been fighting litigations for the last 30 years.
To be going back and forth.
Yes, my lords. That is exactly what is.
But in item 75, 76, this is the assistant settlement officer has overturned what was the record of rights published, what's shown to the list given. So that is he no way connected, is not a order passed in the context of section 12 of the Act. So that is why I say this is without jurisdiction.
So in those where the ADM orders have been overturned, there at least the same orders may be passed, where it's quashed and it is directed that you settle it in favor of the petitioner. Those direct orders need to be passed where the impugned order is wholly without jurisdiction. And as Mr. Mukherjee said, it is at the instance of one bureaucrat that these ASOs have passed these orders. Those are on record. That affidavit is a part of the record.
Going a step further, I have a case 122. My lease, revisional authority has upheld my lease under the same act. Means under the OGLS Act, lease was granted. It was supposed to be cancelled. I came before this honorable court, matter remanded back. Revisional authority upheld my lease. 120. ASO is sitting over that. Absolutely. ASO is a jurisdiction of having collecting revenue. He is sitting over the OGLS authority's order saying that lease is cancelled.
My lord, item 88 and 97, same. My lord, without even issuing notice, they are setting, giving it to recording to government.
And I have a judgment in my favor. Sita Devi Agarwal's case, identical issue arose.
So what we can, Mr. Mohanty, then do this principal objection seems to be, how is a settlement officer interfering with what should be done under the OGLS Act?
Exactly.
So we say that if the government wants to reclaim any part of this land, then it should proceed only under the OGLS Act and under no other act.
Absolutely.
So we'll settle the whole thing that way then.
Yes.
That if the government wants to, then it has to go only by the procedure under the OGLS.
That is there, always there. 3B is always there.
That will be the procedure.
No, in some cases, OGLS invoke hari
Operations were initiated, is it?
In Sampur, it is going on, I know. In Sampur Mauja, the settlement operation is gone. So far as Andharwa is concerned, Mr. Samantrai will say.
So except Mauja,
75, 76, that in Jotani Tos.
so my lord,
Are there settled?
so but this Mauja Ugalpada is concerned, my lord.
Yes,
Soon after passing of the order by the assistant settlement officer, my lord, challenging the legality of this said order made before this court. And this court, after considering the grievance of the petitioner, has made necessary arrangements, interim arrangement, not to publish final publication or to maintain status quo, my lord. Still in force. So therefore, what I beg to say, that once the interim order protection is given, and the any final publication will also be contrary to the same.
That what
If I can show your lordship those judgments, my lord. The judgment passed by this. I mean, order passed.
All these Maujas, where the
Actually, yes.
where the suitland is situated, in all the Maujas, wherever in some Maujas, final publication is already made. In some it may direct that all these settlement operations should be ended within 6 months or 8 months, and thereafter, if any agreed person is there, he will challenge it before the competent revisional authority.
Same thing, Lord.
Or in case the right title interest is anyway jeopardized, he will prefer the civil.
Challenge powers of the ASO. He cannot do.
Kindly see the order I have given you,
He
Lord.
will challenge before the revisional authority.
How? What?
Why should we go to revisional authority? When they
Identically placed situation, my lord. That was the case of identically placed situation. ASO passes order over the OGLS settlement, set aside that and directed to record it.
Every order have.
So Samantara, you gave us a bunch of things. Please give it back. That bunch of
Judgment
your list of dates and all of that.
And Manas, I do not know whether it contains, otherwise I have provided the judgment.
Mr. Samantrai, which you have just now passed on those 3 to 4 judgments, orders of 2014. Kindly give us. Kindly pass on.
1830, madam.
No.
Ask Mr. Samantrai.
Samantrai. Mr. Samantrai, we have given it to given them back to you that please forward it again.
Other judgment is not available with me.
No, just now you have passed on that we have returned you. You please again pass it on. 2014 orders, 2-3 orders you have.
2014.
List of dates also.
All right. There's one judgment of Justice Mahapatra, I think last year. That in that judgment, my lords, the court holds that even if the final publication has taken place, those publications are all eyewash.
I know, in that 1993 OJC writ petition. Yeah, this is.
Paragraph 50 at page number 24.
ଦିଟା ଦେଲନି ହଁ ଦିଟା ଦେଇଦେବି ଆଉ ଗୋଟେ ଦେବି
The same thing.
Two cups.
That's it. This says the same thing as some of the other orders. This is said in some of the other orders of the division bench as well.
Justice Naik has quashed if any publication is there that stand quashed also.
No, Justice K.R. Mahapatra also has done that.
We wanted one sentence could be important. Few orders have in effect resulted in cancelling the lease granted in favor of the beneficiary, which is not within the domain of the settlement authority.
Yes.
Yes. That is good.
Yeah, it's just Mahapatra. Correct, correct. Remitting back is what is problematic. But why was the matter remitted back then? It shouldn't have been remitted back at all.
All the cases are remitted back.
That's right.
In fact, the order which I have referred to, they have been list here.
Yes, that's right. Otherwise, endlessly the same thing going on and on.
Yes. In Padmanath Prusti, Justice S.K. Mishra and Justice D.P. Chaudhary.
We have that order.
Yes. There they have settled it here itself.
Correct, correct.
And they have, the state's objection was recorded. It's an elaborate order, man.
Correct, correct.
And another case, Babita, so I will also refer to that order. Your Lordship, kindly, I've just.
People have constructed their houses, they are residing there.
In some
cases, now
sending us back, my lords, would cause grave prejudice.
Settled.
Yes, yes. So simply the government can, they want to do anything, they do it in the OG. So many orders now, so there's no power to government over. And he has no jurisdiction. Correct. Rule 29 of the Odisha Survey and Settlement Rules 1962. Stop. That was because in terms of Section 13 of the OSS Act, the final publication of the list lends a presumption of correctness to every entry made on the ROR. And the remedy for a person aggrieved by such entry in the first published under Section 13 of the OSS Act is to go by way of a revision petition under Section 15 bracket small b of the OSS Act. That is a revision petition before the Board of Revenue. Full stop. Where there is no such final publication of list, and an order has been passed by an ASO at the stage of publication of the draft ROR under Section 12 of the OSS Act, the remedy lies by way of an appeal under Section 12 capital A of the OSS Act. Full stop. Paragraph. In some of the cases before us, such appeals were in fact filed and rejected by the appellate authority under Section 12 capital A of the OSS Act, perhaps on the ground that in the meanwhile the final list had been published. Full stop. However, the position is not very clear from the pleadings in these. Full stop. Therefore, two scenarios can emerge. That is, one where there has been a final publication of the ROR in terms of Section 13, the OSS Act, read with Rule 29 of the OSS rules, and another where there has been no such publication, final publication of the ROR. Full stop. Nevertheless, in both scenarios, a common feature, as already noticed, in all these repetitions is that ASOs have passed orders declining the request of the petitioners for recording their names in the ROR in respect of the land in question. Full stop. It must be noted at this stage that in all these writ petitions, while issuing notice, this court had directed status quo to be maintained. And that interim order has continued. Full stop. In most of these writ petitions, no counter affidavits have been filed, despite the petitions having been pending over 8 years now. Paragraph. Be that as it may, it is plain that in all these cases, the ASOs exercised single quote suo motu powers, unquote, to override the orders of the ADM under the OGLS Act in favor of the predecessors and interest of the petitioner, or refuse to record their names in the ROR despite there being no objections to the draft publication. Full stop. Clearly, the ASOs were acting without jurisdiction and beyond the scope of their powers under the OSS Act. Full stop. In that, full stop. It is obvious that powers which could have been exercised only under the OGLS Act was sought, which is impermissible in law for them to do. Full stop. The extracted portions of the orders of this court conclusively settle this legal position and does not therefore bear repetition. Paragraph. The question that arises is, what should be the consequential orders passed by this court consequent upon the setting aside of all such orders of the ASOs and the appellate authorities under the OSS Act, which were beyond jurisdiction, which were without jurisdiction. Full stop. One is, as has been done in some of the cases, to remand the matters to the ASO for a fresh decision by following the correct legal procedure. Full stop. However, that course does not commend itself for the simple reason there have been several rounds of litigation already involving these very petitioners and the lands in question. Such a course might only multiply litigation when the legal position is already very clear. Full stop. If the government seeks to recover land which it believes belongs to the government, then there are enough provisions under the OGLS Act to take care of such contingencies. For instance, under Section 3, capital B, is it?
Is Section 3, capital B.
Of the OGLS Act.
No, Section 7.
For instance, Section 3, capital B
Section 3 by the
of the OGLS Act provides for resumption of land and imposition of penalty. Full stop. The rules made under the OGLS Act set out the detailed procedure for exercise of such powers. Full stop. In other words, the government is not powerless or remediless in such a contingency. Full stop. There is no need for an ASO exercising under the OSS Act to take upon himself or herself the task of seeking to recover government land when there are no such powers vested in the ASO under that act, under the OSS Act. Full stop. Paragraph. In that view of the matter, the following directions are issued in all these writ petitions. 1. The impugned orders of the ASO declining to accept the request of the petitioners for recording of their names in the ROR in respect to the lands in question on the ground that they belong to the government are hereby set aside. 2. The corresponding orders by the appellate authorities affirming such orders of the ASO are also hereby set aside. 3. A direction is issued to the ASO to now proceed to record the names of the respective petitioners concerning the land in question in their names in the ROR, in accordance with law.
My lord, wherever the recording is already over, is already made, this correction cannot be
we'll just say
your lordship may take care of.
within a period of 8 weeks, stop. This direction will apply where there has been no final publication of the ROR in favor of any other private individual. Full stop. Paragraph. Where there's been a final publication of the ROR showing the land in favor of a private individual, then...
My lord, in all government khata it is recorded.
Okay, then that we don't have to do anything more. Then the direction will hold good. That recording of the land in favor of in the name of the government will be stand cancelled.
Yes,
that has to be the recording is to be cancelled. That is what I am saying. That they will prefer revision before
because by this court's order, you see, where the land has been recorded, the RO has been recorded in the favor of a private individual, then the ASO will issue notice to such private individual. And after hearing the such private individual,
perhaps there is, if any.
Yes,
perhaps there is no such case. All
okay.
Yes. So if private is there, it won't harm us.
Yes.
So this direction won't harm us, but sending us to the revision authority will cause great prejudice.
Orders will be passed only after hearing such private individual, where the land stands recorded in the final published ROR in the name of the government.
Yes.
That recording of the land in favor of the government will stand cancelled by virtue of this order.
Yes.
And the ASO will proceed to record it in favor of the petitioner in the respective petitioners. Full stop. The above directions will be carried out within the period of 8 weeks from today.
My lord, may kindly give some more time because there are a lot of cases. 6 months may be given. Because there are a lot of cases. My learned friend knows
within a period
hundreds of cases.
Okay, within a period of 4 months from today. Then it is made clear that this order will not prevent the government from exercising its powers under Section 3, capital B.
Capital B.
In accordance with it. Right. The writ petitions are disposed of in the above.
My lord, let me say one thing. Now many settlement camps are closed. Now the Tahsildar is the authority who will record.
That now Tahsildar is the acting as the settlement officer. That is the internal arrangement. That will be done.
Rule 34.
That is an internal arrangement that your lordship's order. Other cases of similar nature also.
Give us a list then.
We'll provide it. We'll give.
Now all of them will come up with all the numbers now.
Yes.
There may be many fence sitters.
Some of the cases that can you give the list?
Now I know. That's what I'm saying. Many of you are fence sitters watching what is happening.
Yes, my lord. I had 1897.
No, of course. Please give us the list.
We'll give, Milord. Even if they are not on board, we'll give the list.
Even you can even mention it after giving the list to Mr. Mohanty. Let him verify it.
Yes.
And then we'll pass orders, similar orders.
If your lordship will don't mind, this may be approved for reporting.
Yes, of course. Of course. It's reportable.
Other matters I have already. Can I give?
We're not indicating individual dates anyway.
It is a general judgment.
Yeah.
We are all grateful.
Thanks. That's all. Consistent with it. All right. Where are we now? Which button?
Item number 104. Messrs. Kalyan Patnaik, sir.
Mr. Patnaik, just call Mr. Kalyan Patnaik.
Mr. Kalyan Patnaik.
You have a batch of 5 petitions or only 1 petition?
No, my lord. 7 petitions.
So which are the numbers? Give us proper numbers then.
104 to 108.
89, 90, 104.
One by one, please.
104. It is from ADM's order.
89, 90.
15 to 108. 106, 107, 108. These are for individual case.
That's right. So
Direct lines.
you have to give us all the numbers.
Yes, ma'am. I will.
Lord, I'll be giving one more number, 131.
131. All right.
Wiki list item number 35.
though it is a OGLS matter, but it is in a different footing because ADM has cancelled the lease without giving notice to the vendor. Present.
That's the usual.
That is the usual order.
Yes,
But
yes.
one thing has to be seen that whether he has purchased it before cancellation.
Yes. That I have understood, my lord. I have purchased in the year 1981, but it has been cancelled in the year 1998, my lord.
All right.
Okay. Then it's
in both matters.
Yes, my lord.
Remand.
35 and 36, both same.
All right. In 35 and 36, it is not in dispute that in both these petitions, the petitioners purchased from lessees under the OGLS Act for the lands in question prior to the exercise of suo motu revisional powers by the additional district magistrate bracket ADM. Full stop. It is also not in dispute that no notice was issued to either of the petitioners before cancellation of the lease by the impugn orders of the ADM. Paragraph. Consequently, as far as writ petition civil 293 is concerned, this court exercised the order dated 30 June 1998, passed by the ADM Bhubaneswar in lease revision case number 6980 of 1998, and remands the matter to the ADM for a fresh adjudication in accordance with law. The lease revision case number 680 of 1998 will now be listed before the ADM Bhubaneswar on 6th March 2023, on which date the petitioner will appear with a downloaded copy of this order. The ADM will then proceed with the matter with law and pass a fresh order within a period of 4 months thereafter. Till then, status quo shall be maintained by the parties. Paragraph. As far as 2934 of 2014 is concerned, this court sets aside the impugn order dated 30 June 1998. Only the lease revision case number is 680 of 1998. We'll repeat the whole thing, and then you say both writ petitions are disposed of in their own terms. The court cannot express on merits.
But in item 36, my lord, the date of registered sale date is 4 to 1983.
It's all
prior to that.
All right.
Yes, ma'am.
Item number 37. Item 37.
None appears dismissed.
Item number 38.
My lord, in item 38, my learned senior Mr. Mukherjee has been specifically engaged, my lord. My lord, he was here, but due to some difficulty, he had to leave, my lord. I pray for
then.
My lord. Obliged.
39.
Would I be kindly excused, my lord? But that item 131, in fact, your lords may take it up independent of these orders, my lord.
All right, then don't include
Because there's an order passed by the settlement officer, not by the assistant settlement officer.
All right.
So your lordship should take it up, my lord, separate.
All right.
Item 39. I'll call it. Item 39.
None appears dismissed.
Item number 40.
Item number 40 and 41, I may be permitted to withdraw with liberty to approach the appropriate forum.
Or counsel the petitioner seeks leave to withdraw these petitions with liberty to approach the appropriate forum. Disposed of is withdrawn with liberty spirit.
Obliged.
Item 43.
No instruction if cause of action survives. 43,
43, 56 and
54.
54. Right. Counsel the petitioner states he has no instructions.
Obligement.
Item 50.
Item
50. High jurisdiction.
My lord, have come up against the order of the learned Tehsildar in OEA case numbers 798 of 1991, my lord. The order was passed in the year 2003, my lord. In there, my lord, I was not a party and the order is also a non-speaking order, my lord. No detailed observation was given by the Tehsildar and why the land was settled in favor of the private opposite parties. During the pendency of the writ application, my lord, the opposite party number 4 has died.
And notice has also not gone from the writ petition in last year. No notice has been issued.
We have filed substitution petition.
I know.
That is also on record, my lord.
I know. We can allow that substitution application, but you'll have to go back in appeal because no notice has been issued so far in the writ petition. This is an appealable order, correct?
Yes, my lord. And for the first time, it is listed.
Correct. No, it's listed.
No,
He
it was
kept
listed
asking for
before.
adjournments and all that.
Only 2 adjournments.
Oh, only 2. The point is, it's a 2014 matter and no orders have been passed till date. In this writ petition of 2014, no effective orders have been passed till date. Full stop. During the pendency of the writ petition, respondent died. Full stop. IA number, Miss Case numbers 16220 of 2017 has been filed, seeking to bring on record the legal representative of opposite party number 4. For the reasons stated therein, that application is allowed. And the party mentioned in schedule is substituted in place of opposite party number 4 paragraphs. In the main writ petition, you say, till date, in the last 8 years, no notice has been issued in the present petition which challenges an order dated 27th April 2001 passed by the OEA collector Brahmagiri in OEA bracket S case number 812 of 1991. Stop. Admittedly. So what is the explanation for the delay in filing the writ petition?
The petitioner were not aware of the such settlement, my lord, in favor of the opposite parties. Because the petitioner is a private deity, my lord. For that reasons, my lord, the private opposite party recorded the land behind the back, my lord.
12-year delay can't be explained like that. The court finds that there is no valid explanation for the inordinate delay in filing the writ petition in 2014 to challenge an order of 2001. The explanation offered in para 9 that the petitioner had no knowledge of the impugned order is too weak to merit acceptance. Stop. The writ petition is accordingly dismissed on the ground of laches.
51.
51 and 52 are same.
Yeah, in view of the dismissal of writ petition civil 9068, these writ petitions are also dismissed.
At note 53.
That is the settlement matter, service settlement. That is service settlement matter.
Old matter.
Is it covered by that earlier order?
Yes.
All right. So include this.
It is covered.
All right.
53 and 58 is also covered. I have told.
58.
Yeah. 53 is covered. All right.
73.
Whatever you've given there, sir.
73 and 96.
55.
May I please, Manoj, I'm in the VC mode, Manoj.
Yes.
Herein the award of the labor court is challenged. The sub-item 1 relates to the challenge made by me. I'm for the sole worker, Manoj. And the second sub-item relates to the challenge made by the management. Manoj, the first issue, which was with respect to the termination of my services, now that has been answered in my favor, that there was a resignation which was taken by coercion. Manoj, my humble submission to this effect is the award which was granted therein was, Manoj, that in lieu of the reinstatement, I'll be given compensation. Compensation would be rupees 1 lakh.
For how long did you work?
I worked for around 17 years.
Oh,
my
all right.
Manoj, your lordship may kindly consider.
But who's appearing for the other side? Has notice been served?
Yes, yes, madam, my lords. I am on VC, my lords.
Yes.
Am I audible, my lords?
Yes, please.
My lords, this writ application, I mean, the management has filed the first writ application in 2013.
Yes.
The workman had not challenged the earlier, I mean, the award earlier.
Right.
When the management filed, my lords, he filed this subsequent writ application in 2014.
Have you paid him that 1 lakh?
No, I have not paid, my lord.
So what we'll do is we'll ask you to pay it with 6% simple interest, then it will get enhanced automatically.
Yes, my lord, that your lordship can do that. What I'm praying, your lordship knows it's a jute factory, my lord. It's a seasonal and it is obsolete nowadays. My lord, after this poly bags and all those things are coming, demand is not there. It is not functioning. I have taken the ground in paragraph 14 of my read petition. Your lordship may kindly see. The existence of the petitioner establishment is a stake, my lord, and it is running for 8 months only, my lord. It's seasonal. So I filed this to reduce. If your lordship will not interfere, let both the writ application be dismissed, my lords, and your lordship.
But you have to pay interest, sir. You have to pay interest. You've got a self.
Because of this, that I pray, my lords. Because of the content.
Yeah, but it stays there for 9 years, sir. Now.
No, stay was there. And this resignation, he is the union leader, my lords. The workman is not workman is the union leader, and in presence of two union leader, this and the labor court has held that this resignation was given by the workman himself.
No, that issue is already answered, my lords. And the lordship, paragraph 12.
That your lordship may kindly come to paragraph 7 of the finding page 20, my lords, in my writ application.
All right.
Paragraph 12.
I pray, my lords, if your lordship not only move to reduce the amount, at least that may be that 1 lakh I will pay. I'll convince my.
No, not 1 lakh can't pay after 10 years like this, sir. You'll have to pay with interest. You say the challenge, these two writ petitions, one by the management, bracket, writ petition civil 17036 of 2013, bracket, the other by the workman, writ petition civil 9356 of 2014, are directed against the same impugned award dated 23rd February 2013, passed by the in ID case number 89 of 2006. Full stop. The issue referred to the Labour Court for adjudication was as under, this reproduced from page 16 in writ petition civil 17036 of 2013.
2001 termination and 2006.
On the basis of the above reference, the following issues were framed by the Labour Court. Take from page 19. Paragraph issue number 1 was decided in favor of the workman by holding that the workman was in fact refused employment in contravention of section 25, capital F, the Industrial Disputes Act 1947. Full stop. It was factually found that by the Labour Court that the workman was not allowed to enter inside the factory premises on 24th January 2001, whereas the resignation, bracket exhibit A, was supposed to be tendered 5 days later. Full stop. Paragraph. Having heard learned counsel of the parties and having examined the impugned award of the Labour Court, the court is not persuaded that the above finding suffers from any illegality or perversity. Full stop. The Labour Court has noted that a careful examination of the original of the letter of resignation revealed that the contents thereof were in the handwriting of the workman, but the date, single quotes 2901.2001, unquote, was open quotation, written by someone other than the workman, unquote. This being pure question of finding of fact, this court is not persuaded to interfere. Paragraph. Having come to the above conclusion, the Labour Court did not order the reinstatement of the workman. Directed that he be paid compensation in the sum of rupees 1 lakh. Full stop. Paragraph. The workman has filed the writ petition claiming the above compensation amount to be inadequate, considering that he had put in more than 15 years of service.
17 years, my lord.
No.
Till the, I was said more than, sir, till the date of the termination. Paragraph. Counsel the management, on the other hand, pleaded that the unit was in dire straits. The compensation amount was excessive. Paragraph. The court notes that when the management's writ petition was heard first by this court on 31st July 2013, while issuing notice, this court unconditionally stayed the impugned award. Full stop. In other words, the management has enjoyed a stay order for well over 9 years now. Full stop. From the point of view of the workman, he has got nothing despite succeeding before the labor court. Paragraph. Keeping in view of the circumstances, the court directs as under 1, the impugned award of the labor court to the extent the services of the workman to be illegal is hereby upheld. 2, the compensation amount of ₹1 lakh awarded to the workman is affirmed. However, a direction is issued to the management, that is the petition and petition civil 17036 of 2013, to pay the workman the aforementioned sum of ₹1 lakh within a period of 8 weeks from today, together with simple interest at 6% per annum from the date of the award, that is 23rd February 2013, till the date of payment. If the payment is not made within a period of 6 weeks, 8 weeks from today, the management will pay simple interest at 9% per annum for the period of delay. Stop.
May I pray, my lords?
Yes.
My lords? Instead of 6% interest, you'll also may direct, I'll pay 25,000 or 30,000.
No, sir. No. This is better.
Grateful, my lords, grateful.
Right.
Obliged.
Right. Item 57.
None appears dismissed.
Item number 59.
The petition is an association established at the petition is an association discharging the public duty, my lord, and they have made the application to the government under Annexure 3 and Annexure 5, my lord, to settle the land in favor of the association, my lord. This representation, when both the representations are pending, without considering that representation, the government has initiated a proceeding under the OPP Act, madam. And ultimately, the order of eviction was passed. And both the applications are pending till date, madam. Both the representations are pending since 2010.
no action was taken on that. On the other hand, the OP proceeding was initiated against the person concerned without implementing the association as a party. And ultimately, the previous writ application, this Honorable Court directed to implement them as a party, and ultimately the matter was heard by the Director of State. And the order was eviction was passed, madam. That is on Annexure 14.
No, but that order is an appealable order, no?
But there is an appeal, madam.
No. Why can't you file an appeal against the eviction order?
Well, the appeal was the appeal order is Annexure 14, madam.
The appellate authority has passed the impute order. My lord, the only ground is that made the representation, so you cannot be evicted.
That
from
can
the
hardly be the
How
ground.
can it be a ground? You have fought the case, you contested your claim, and ultimately it was order was passed on.
So on merits, you have no case.
Yes, my lord.
Well, the grounds which I have taken in my appeal memo, you will also make kindly have a glance to that.
Yes.
That has not been considered by the appellate authority, madam.
Yes.
My specific stand that the association is in occupation of the property since last 22 years.
So,
and the government has also granted many
extensions,
grants for discharging the public duty, and to the order is also there, man. So the order is there, and in the appeal memo have categorical stated.
See, if they want to allot you some other land, it's up to them.
Let them.
My lord, there are thousands of NGOs or associations, clubs in Bhubaneswar. If we will allot land to everybody like this petitioner, then the entire town will be blocked.
No, but these people have an interim order in their favor.
That interim order is there. That is why they are still in possession of the OPP. Order, but the original authority passed the eviction order that was confirmed by the appellate court. Then they have preferred this writ petition.
But the representation under Annexure 3 and Annexure 5 is pending.
That's not a ground to resist.
The Lordship may direct that within 3-4 months they will vacate the premises. That's all. The interim order may continue for 4 months. Then they will.
Are you prepared to file an undertaking, affidavit of undertaking?
They will file undertaking before the director GA department.
The order which was passed, which I have not claimed. I have never claimed any right interest over the property. I am not claiming any adverse person against the property.
How can be adverse possession?
Department. The observation of the made with the director. As if I am claiming adverse person in respect to the property. So I said that since the institution is functioning for last 30 years, with the knowledge of the department, madam.
Yeah.
It's a different department. And they are granting aid also. The government is granting aid to this institution.
That's all right. Only you have to shift your location somewhere else.
Any other place, the government will consider that any other place will be.
He said the challenge.
Let them consider my Annexure 3 and Annexure 5.
The challenge, the present petition.
Provided they vacate the land within 3 months, we will consider.
Is to an order dated 10th August 2013, passed by the Director of Estates, dismissing the petitioner's appeal, OPP appeal case number 19 of 2013 bracket L, thereby confirming an order dated 8 March 2013, passed by the Estate Officer, General Administration Department, bracket GAD, in OPP case number 212 of 2012, bracket L. Stop. While directing notice to issue in the present petition on December 2017, this court directed that state shall not allot the disputed lot in favor of any person till the date of listing. Stop. That interim order has continued for over 5 years now. Correct. The background to the petition is that the petitioner is an association of purportedly engaged in social work and is also receiving grants from the government of Orissa and the central government. Also central government, is it? No, or only government of Orissa? Grant from government of Orissa?
Yes, ma'am. Yes, ma'am.
Okay, receiving grants from government of Orissa. Full stop. The petitioner was granted, no, was allotted the land in question. At lot number, no, over an area of AC 0.100 decimal under the Orissa Government Land Settlement Act 1962. By a letter dated 1st December 2010. What was the period, sir? For which? Section 3.
The prisoner occupation for the last 24 years.
No, you're allotted for how much time?
I have not claimed for any period, madam.
You may not have claimed, sir, but the allotment was made for which period? Was there an allotment of land or no allotment?
There was no allotment. They were encroaching.
Occupying?
Yes, they have.
Because the way they've written in the writ petition, you see that?
They have only made a representation that it may be settled now.
This is never allotted to you.
No, it has not been allotted.
We would have initiated any.
No, just see para 4.
Madam.
You say it has been functioning over a piece of government land, which means you basically encroached on government land.
Yes.
Oh, this is a nice way of writing it, sir. You're saying you're functioning over government land, so one presumes that you're validly occupying government land.
No, but it has not been allotted. For that reason, we made representation to the government. And for allotment.
I know, that's what. Only attempts when you stay your lease.
Only 10 days.
Let's take that off. You see, in para 4 of the petition, it is stated that the Petitioner Association, open quotation, has been functioning in its office at Rental Colony, Bhubaneswar, over a piece of government land from the date of its formation. Unquote, the land is said to be of an extent of AC 0.100 decimal. So the fact of the matter is that the Petitioner Association has encroached upon government land. And till date, it has not been formally allotted to the petitioner. Stop. Paragraph. As a result, eviction proceedings under the Orissa Public Premises Eviction of Unauthorized Occupants Act was initiated against the petitioner. Encroachment notice dated 7th August 2012. Paragraph. The only ground on which the notice is resisted is that the Petitioner Association had made 2 representations for allotment of the formal allotment of the land in its favor, which were pending with the government. Stop. That could hardly be the ground to resist the eviction notice, since the Petitioner Association had been unauthorizedly occupying government land without paying anything whatsoever to the government for over 22 years. Paragraph. Having heard the counsel of the parties, the court is not persuaded that the orders dated 8 March 2013 of the estate officer and 10th October 2013 of the Director of Estates, affirming the eviction of the order of eviction of the petitioner to be suffering from any illegality whatsoever. Consequently, there's no merit in this writ petition and such. Full stop. The dismissal of this writ petition will not come in the way of the petitioner. Seeking allotment of any other land. No, approaching the government, from prevent the petitioner from approaching the government seeking allotment of any other land in its favor. Full stop. The writ petition is dismissed and the interim order is vacated.
Well, till then the protection may be given.
Till when?
There is no till.
Till when, sir?
Till the allotment of any other land.
So if they take 20 years to consider, you'll be protected till then. So this writ petition dismissal will have no meaning.
But they have not yet considered for that.
So if they take the next 30 years to consider, you will be protected till then. That's the meaning of the order we have passed now.
The protection has been given, and ultimately the public is having no vested interest over the property.
Sir, you have unauthorizedly you have encroached on government land for 22 years now without paying a shred of money. Just imagine if we calculate the market rate.
But it's a pioneer.
It worked to some maybe 20 or 30 crores. Will you deposit that, sir?
But it's a 10 decimal only, my lord.
Oh, no, how much? Tell us the market value of that 10 decimal.
It's a 10 square feet.
No, what is the market value of that? Will you pay that?
10 square feet. 10
100 decimal.
10 decimal.
10 decimal.
10 decimal.
10 decimal is in Bhubaneswar, it is near about 1 gunt of land in rental colony.
For 22 years, you calculate the market rent and deposit it in the court. Are you prepared to do that?
I have to take instruction on that.
Then you take your time taking instruction. Meanwhile, writ petition is dismissed. All right.
Item number 60.
59.
Item 60.
None appears dismissed.
Item number 61.
For the opposite party.
None appears for the petitioner. Dismissed.
And presence be noted.
Item 62.
None appears for the petitioner. Dismissed from opposition.
My lord, in fact, the representation submitted against the 13-2 surface and notice.
Now you have remedies under the DRT. You will have no. For the DRT, you have a remedy.
No, now till
it's all over now. No orders have been passed here, sir.
They have not taken any action under section.
Then you stay happy, sir. For the last 8 years, they've taken no action.
No, 13-4 has not been.
So you're in a very, very happy position, sir. Why spoil your peace? We'll ask you to now deposit whatever you borrowed. Are you prepared to do all that? Your client is very happy. You've gone and disturbed his peace now. You withdraw this writ petition, sir.
Approach the authority.
Counsel the petitioner seeks leave to withdraw the present petition with liberty to seek other remedies that may be available to the petitioner in accordance with law. Disposed of as withdrawn with liberty is paid for.
Item number 64.
No instructions. No instructions dismissed. Memos taken on record. No instructions dismissed.
Item 66.
In this case, my lord, the petitioner challenged the order passed by the industrial terminal by the annexure of 2, my lord. And there is 2 writ petition as a file. One is the workman has filed another writ petition, that is WPC number, my lord, 27000 of 17, my lord. I pray lordship call this matter along with that petition. Next week, the matter can be disposed of.
I am for the workman, your lordship. Second item, that has also, so that file has also been in the list.
It's already there. Tell us.
The learned tribunal directed my lord for reinstatement without baggages my lord. The petitioner my lord is working as a NMR my lord, as a helper in electrical engineer, Ralph municipality my lord. And he was though he was a
reinstatement without back wages, you have still challenged.
That is very strange, your lordship.
Remarkable, sir. How many years did you work?
10 years, more than 10 years.
And without back wages, you have challenged that. Very good.
unauthorized after that he has turned off my lord in spite of authority.
And that also you got state. What is your age now?
My lord, now your lordship.
47 years in 2014.
51 years in 2017, my lord. In
no, 2014 he was 47, sir.
My lord.
See,
8 years gone.
He has written
55
years in 2017.
51 in the year 2017.
Now
51 years.
So you are about 58.
56,
my lord. Now problem is, your lordship, that workman, that the order has been passed without any back wages and consequential benefit.
Correct.
But junior to me, they have been brought over to regular establishment. They are now getting full salary. For that reason, this workman has filed this case. Your lordship, I don't pray for that back wages, only consequential benefit. Otherwise, your lordship, my services will not be regularized. For that reason, your lordship, workman has filed this case.
The two writ petitions have been challenged. The present two writ petitions, one by the management, writ petition civil 1169 of 2014, and the other by the workman, writ petition civil 27200 of 2017, are directed the same impugn award dated 19 November 2013, passed by the Industrial Tribunal Rourkela in industrial dispute case number 1 of 2007.
My lord,
the following dispute was referred to the tribunal for adjudication. Take from page 13. Paragraph. The Labour Court has found, as a matter of fact, on analyzing the evidence, that
paragraph 10, your lordship.
Yeah. That the termination of the services of the workman was illegal. Workman who was working as an NMR electrical helper was neither legal nor justified. Stop. Even the minimum principles of natural justice were not complied with by giving an opportunity to the workman to have a say in the matter. Paragraph. Having heard let counsel the parties, the court is not persuaded to interfere with the above factual finding, which is based on an appreciation of the evidence led before the tribunal. Stop. Paragraph. The only relief granted by the tribunal is the reinstatement of the workman without back wages. Stop. Since on merits, there is no case in favor, is not inclined to interfere with the above relief granted to the workman. Paragraph. The workman's grievance that his reinstatement is without any consequential benefits appears to be justified. Stop. He points out how junior to the workmen have since been brought on the regular establishment of the municipality. Paragraph. Accordingly, the relief granted by the tribunal is modified by directing that the petitioner will be reinstated forthwith with all consequential benefits. Stop. The interim order is vacated. Writ petition civil 116991 of 2014 is dismissed, and writ petition civil 27200 of 2017 bracketed by the workman bracket is disposed of in the above terms. All right.
Item 67,
None appears.
68.
Same order.
69.
None appears dismissed.
Item number 70. 70.
And this is the case under section 33C2 of the ID Act.
This
An expert order
workman has not been served, sir.
My lord.
The workman was not served.
Grounds, my lord, I filed a petition to recall the expert order. That petition, even though there has been no objection by the workman.
The workman was not served in this writ petition, sir.
Workman.
68.
I didn't know. I have no.
What is there on merits? Let's see. What is there on merits?
Merits, my lord, I will take your lordship to some dates passed by the labor court. I was set expert 16 February 2005, my lord. Thereafter on 21st/4/2006, your lordship kindly turn to page 9 of the petition. That is order number 17. Order number 17 that is dated 21st April 2006. The applicant is present. He files a petition along with Form G in favor of the GM Sinha and the S.C. Sahu advocate and prayed to allow the said petition, and the applicant may kindly be permitted to be repented through lawyers. Hard, the petition allowed and Form G filed by the applicant is accepted. At this stage, the advocate for the applicant files certain xerox copies of the documents as per the list. The same is kept on record. The applicant files affidavit evidence in chief in support of his case. Perused. The case, the same also kept in record. Put up on 30th August 2006 for further ex parte examination in chief. Applicant with regard to the making of the documents, marking of the documents as exhibits. Then, my lord, kindly turn to next 20. The representative of the opposite party is present. None appears for the applicant. No steps taken. PO is on leave. Put up an letter for hearing of the petition. The applicant may file the objection to that. That before that, order number 18. On that day, I have filed a petition to recall the ex parte order. That was kept on record, and that was also copy served on the workman. But that petition was posted for hearing of that on that petition, and he was asked to file the objection. On next date, on order number 22, the representative of the opposite party files Hajra. None appears for the second. Put up on 30th 11/2007 for hearing of the petition. The applicant may file objection, if any. In the meantime, the opposite party is informed. Inform the applicant. Then next order is order number 23. The representative of the OP is present. Notice could not be issued to the applicant due to want of service postage stamp. Put up on it for hearing of the petition. Then next order is order number 24. The representative of the opposite party is present. None appears for the applicant. No steps taken. Put up on 9/6/2006 for hearing of the petition. The applicant may file objection, if any. Then next order is 26. 26 is both party absent. Then 27 is non-applicant. The representative for the OP is present. As I am busy in the transit case, the case is adjourned to 11/2/2009 for hearing of the petition. The applicant may file objection, if any. So many adjournments were given. Then order number 31. Both parties are absent, no steps taken. Then power under section 7 of the ID Act has not received. Then you change, my lord. Then order number 32, the representative of the opposite party is present. None appears for the applicant. No gazette notification vested under vesting power under section 7 of the ID Act has not received. Put up on 27 January 2010 for hearing of the petition. Then order number 34, the representative of the opposite party is present, the applicant is absent, no steps taken. However, the case is adjourned to 29/11/2020 for hearing of the petition. Then order number 35, the representative of the opposite party is present, the applicant is absent, presiding officer is on leave. Then order number 37, the representative of the opposite party is present, none appears for the applicant, no steps taken. However, the case is adjourned to 29/7/2011 for hearing of the petition. On 29th, the next order is 38. The authorized representative of the OP is present, none appears for the applicant, no steps taken. The government Labor and Education Department case is adjourned to 22nd/10/2011 for hearing of the petition. Then next order is, in this order, that is order number 39, both parties are remained absent since long. On perusal of the case record, it appears that the opposite party has failed to file a petition by post to set aside the ex parte order passed by this court on 16/2/2005. Prior to that, the applicant has already filed the affidavit evidence along with some Xerox copies of the documents. Since the petition not moved by the opposite party, the same is rejected. At this stage, my lord, it was rejected, but all the previous dates I have presented. But it has mentioned that since long I was absent. But on all the previous dates, your lordship find I was present, but the applicant was absent. But it is mentioned that since long I was absent and I was not taken any steps. At this point, my petition was rejected. Then, my lord, they posted the case for hearing on the ex parte.
Sir, this 3,76,000.
Yes, my lord.
You have to pay by the impugned order, correct?
Well, that's interest is 10%.
So what? How does that work out? This is an order of 15th May 2012, 10 years ago, 10.5 years ago. So if you add that interest to the 3,76,000, what does that sum work out to? At least 5 lakhs, sir.
It will come around.
So you deposit that in the court, sir.
Well, the burden is the 10%, interest is big burden.
So 10% will be much more. You deposit that entire amount in court.
If my lord may consider that the interest part.
No. You deposit that entire amount in court. You deposit this entire. Even appearing, no. Notice is not served yet. You deposit that entire amount in court here, then we will consider.
Then I have to take instruction.
You take. Over phone, you take and tell us tomorrow. All right.